Great, thank you.
No problem.
For some reason, what's happening here is that I have all the passwords for Google, which is what Zoom is asking me to log into, the
Mm,
NMPRC one, Gmail account of the commission. But then they asked me for a second authentication code, which I cannot get because apparently it's being sent to somebody else or
right.
somewhere else.
No,
But
yeah, with
still is not getting them
enterprise,
either.
the authentication stuff really you shouldn't exist for when you're using a system like this for like enterprise purposes, right? Like because the whole point is to like let the agency share use. So it kind of makes no sense.
Yeah, I know. This is
But
a
we've been
problem.
using like basically, I think, non-commercial accounts to do all this stuff, which is why we keep running into because we've had that same issue with Dropbox, which was the authentication problem.
Yeah.
Anyway, we are on YouTube, so we should probably.
Okay, so can you then send me the Zoom link then? Can you copy and paste and send it to me to post it?
Yeah, I got to oh, crap, I forgot to do that before we
If not,
how
I'll
do
go to no, then I'll go to the commission's YouTube channel and I'll get it from there.
yeah, if you wouldn't I'm not sure how would I launch so I'm on how would I open YouTube? Well, let's see. There's a little thing up here.
Chris,
Go
I'm
to
going to
the
step away
website.
just for a minute.
Yeah. How would I launch the YouTube browser that I know is being Oh, you know what you have to do, Anna? You probably have to go to the NMPR. Yeah.
That's what I'm
You just
planning to do. Yeah, so that's okay. Thank you so
okay.
much.
No problem. Hey, Allison,
Yes,
how are you?
I'm good. How are you?
Okay. Can you send me the real time? I saw the session code and the password. I just don't have the link unless it might have been that you sent it to Anna and then I just don't have it. The actual to the case view application or whatever it is.
You need the app. You
I
don't
need
have,
the
I
app.
figured the little case view icon, you need to download it from Stenograph.
Okay, let me do that quickly. What's it called? Stenograph.com?
Yeah, let me take a look.
Stenograph case view.
Yeah, it's Case View Net Cloud. Let's see, Stenograph.
Here I see Case View Net, Stenograph LLC, uh, accept cookies, and then I
Let's
got to
see.
download and downloads. Case
Downloads.
Case View Net,
There you
iPad
go.
for Windows users. Case View Net app. That's probably me, huh?
Yeah, if you're, yes.
I'm on a PC. Yeah. Okay, that was quick. Oh, maybe it's
Yeah,
just gonna
it's just
do
a little.
case view setup. Next, agree. Register to C Ryan organization PRC admin. Sure, why not? Install. Hmm. It's having a problem.
Uh-oh.
Ignore.
Okay, I'm back,
Abort.
Chris.
I had to abort the let's see. Let's try this again. Windows viewer.
You want the
See.
viewer.
Yep.
Yes.
No, and I'm going through, I'm just
I'm
accept the
sorry.
yeah, I'm not just kind of talking aloud. Okay, so register to enter the registration information for case view net. I'm assuming that's auto-populating. It's not anything.
Yeah, in fact, I think you could just pop through it.
Install. Let's see, maybe the error opening file for writing. Stenograph case view net.exec. It's giving me an error message.
Oh dear. Let's see. Looking
Um,
through some paperwork here, seeing if I can.
for iPad users.
I'm sorry, I would have sent you some paperwork. I thought
No,
you,
that's okay. That's all right. No problem. I'm just trying to figure out why. I wondered whether there isn't some setting in our internal IT stuff that blocks your
that is,
ability to, that could be what's going on. They, all these,
I've had that
um,
happen before with law firms with firewalls and what have you.
right. That's very well what could be going on. Hmm. Cloud session allows the core reporter to use an internet connection to stream his or her real-time text to clients using the KSVNet browser edition. Is this the same one Mr. Lee uses? Because when he,
Yes,
so he has been previously sent us a link, I think on your end, and I, if this isn't going to work out, that's whatever, who cares? But if there's a way you can do it, I don't, we'll have to figure this out afterwards, obviously, but
all
like,
right.
if you don't want to get involved with that at this moment, Allison, that's fine. I just don't know. I don't think I'm going to be able to figure out how
Yeah,
to
I
get
don't have it. Yeah, the only thing that I've got is to send you the session code and
in that.
let me
That's fine.
see. No, let
No, but
me,
don't worry about it. It's okay.
we
I'd
got a
rather,
couple. There's only the three of us on now. Let me give me a minute.
sure. Because what I think you could do is I can log on to the cloud and then see your,
Yeah,
it's like basically the same thing. It's without having the app.
yeah, hold on.
Oh, yeah, I'm sure that's what the problem is because it just doesn't allow me to get through. Like it's rejecting the writing process to the machine. So it's got to be an IT firewall issue.
Yeah, I'm gonna have to research this a little more. I think the problem on my end is that CaseView Net is a stenograph software product, and my CAT system is not stenograph. So I can use the product, but I don't have all the features, so I may not be able to.
That's
But
fine. Don't worry about it.
you know what? I'll research it after this and I'll let you know.
It's all good. This isn't a it's not an insignificant hearing, but it's not one where I think the real time will be 100% essential. So it's fine.
Sorry about that.
No, that's okay. It's not your fault. I should have, I guess because we'd always with Mr. Lee done the web link. I sort of assumed that's the way it would go, but good to know that there's another way to do it too.
Yeah, and actually, I've been doing this for quite a while, and that's the only way I've ever done it is just, they've had the little app on their computer and you just plug in the two numbers that I sent you and we're off and running. But when this is over, I'll research it a little more and see what I can do.
Okay, thank you. And we'll try to make sure we can download the app onto our machines because that makes sense that we should have it. I mean, it might be faster because if you're going through the cloud, you got internet lag to deal with, but the app may be more direct and perhaps even more real time than real time.
More real time.
More real than real.
So Chris, I think because you're the host, I don't I don't have the ability to
Oh,
admit it. I don't even see
really?
anybody. Yeah, I don't even see anybody. So it's up to you.
They're all there. I'll admit them all. Here we go.
Okay.
You ready?
Yep. Well, good morning, everybody. If I'm not mistaken, I don't quite see Doñana County on yet. Hearing examiner Ryan, do you want to wait, give him another minute or two, or just go ahead and get started?
You can just get started.
Okay. All right. Good morning. Are there any issues from the parties that we should address before we go on the record? I have several, including one from Mr. Simpson that we'll address on the record, but anything that we need to address before we go on the record? Yes, Mr. DeSalem?
Thank you, Mr. Hearing Examiner. I just want to mention that Ms. Lynch and I are involved in a settlement negotiations, and we have a meeting from 1 to 3 this afternoon. So one of us will be stepping out for probably a couple of hours this afternoon, but one of us will remain in the hearing. So just wanted to let you know that.
Okay, thank you for letting us know. And it looks like, if I'm not mistaken, looks like we now have Doñana County. Any other issues we should address before we go on the record? Okay, seeing none. Then if the court reporter is ready, we'll go ahead and go on the record. Okay. Good morning. The time is now 9:31 a.m. We are now on the record. In this matter before the New Mexico Public Regulation Commission will please come to order. This is the time and place set for the evidentiary hearing in the matter of El Paso Electric Company's application for approval of its 2025 to 2027 Energy Efficiency and Load Management Plan, Utility Incentive, and Revised Rate number 17. This case has been docketed as case number 24-00154-UT. My name is John Kreinkamp. I'm joined this morning by Christopher Ryan. The two of us are hearing examiners with the PRC who will be presiding over this hearing today. The hearing today is being transcribed for a court reporter. For the sake of that record, I'd like to start with entries of appearance from the parties, starting with Epe.
Nancy Burns for El Paso Electric Company. And with me is Angela Harris with Spencer Fane.
Good morning to both of you. Thank you.
Good morning.
I guess next would be Utility Division staff.
Good morning, everyone. This is Ryan Friedman representing Utility Division staff today.
Good morning. Doñana County.
Good morning, Mr. Examiner. Keith Herman with Doñana County. And as another preliminary matter, I was going to request my absence to this hearing. I don't know if you'd like to finish calling for appearances, or I can make that request now.
Yeah, we'll finish with appearances, and then we'll address that pretty quickly. But good morning to you.
Good morning. Thank you.
Coalition for Clean Affordable Energy, Mr. DeSalem.
Thank you, Mr. Hearing Examiner. Good morning, everyone. Charles DeSalem representing Coalition for Clean Affordable Energy. And Ms. Lynch is on as well. I'll let her introduce herself.
Good morning, Kara Lynch with Coalition for Clean Affordable Energy. I am supporting Mr. DeSalen in this hearing.
Okay, thank you. Good morning to you both. Ms. Lynch, are you also here on behalf of Prosperity Works?
Yes, we will. We have submitted a motion to intervene. Thanks for reminding me that I'm also here representing Prosperity Works.
Okay, thank you. Just wanted to make sure I was clear about that. And then last but not least, Mr. Philip Simpson.
Yes, Your Honor, I'm here representing myself as a pro se intervener.
Good morning to you, Mr. Simpson.
Good morning.
Okay, well, at this point, before we go much further, I was going to address just some procedural notes, but I think just because Mr. Herman mentioned his request to not be on the hearing for the totality of it today, we'll go ahead and address that. Mr. Herman, your request for essentially to drop off at your convenience is granted, again, subject to the normal conditions.
Yes, thank you, Mr. Examiner, and that's just generally, I'll be bound by any determination made by my absence. Doña Ana County has no witnesses, and we waive all cross-examination.
Great, thank you, Mr. Herman.
Thank you.
And we had discussed this briefly before we went on the record, but Mr. DeSalen and CCAE had indicated that either Mr. DeSalen or Ms. Lynch, one of them may drop off at some point this afternoon between 1 and 3. But then their co-counsel would remain on the line. Is that correct, Mr. DeSalen?
That is correct, Mr. Hearing Examiner.
Great, thank you. Okay, so there are a couple other preliminary matters for me to address, but before I get to those, just a couple of housekeeping items. So the procedural order in this case did not ask EPE to confer with the other parties to agree on a proposed order of party presentation or witness examination. So the hearing examiners are inclined to defer to the default order set under the rules. As I have examined it, it looks like that would mean that as far as the order of party presentation, again, looking to those parties who have witnesses to testify today, it begin with EPE, then CCAE, followed by Mr. Simpson, and then staff. For cross-examination, the order would be EPE, followed by CCAE, Doña Ana County, if they have any questions, followed by Mr. Simpson, then Prosperity Works, and then finally staff. We do have 7 witnesses who will testify here today. Unless there's any objection or some sort of other consensus from the parties, we were not planning to impose time limits on cross-examination. Obviously, though, we are hoping to finish in 1 day today. Any concerns about anything that I've just outlined there? Okay. Seeing none, so just a couple other preliminary matters. So first and foremost, we had a little bit of a lag in terms of getting some of the exhibits uploaded, but I am assuming at this point that all the parties have access to Dropbox. You've seen all of the exhibits that have been uploaded. Am I incorrect in that at all? Okay, so then the second issue, and I'm hoping that most people have checked your email this morning, but Mr. Simpson has emailed me this morning with an item concerning administrative notice. I directed Mr. Simpson to forward his email to the service list so that all the parties would have some limited advance notice of what he was going to be asking for. Mr. Simpson, while we are now on the record, can I ask you just to summarize essentially what you're asking for, what your request is, so we can start the conversation there?
Yes, Your Honor. I am asking for administrative notice of the recommended decision in 18 dash sorry 18-00280-UT,
okay,
which is the recommended decision in a New Mexico gas company case, and this is related to my suggestion that we include the avoided cost of natural gas when we are doing UCT calculations, because it appears that New Mexico Gas Company has been doing something similar in counting the avoided cost of electricity when they do their UCT calculations. So I thought that was relevant, and I'd like to get that into evidence.
Okay.
So
And I believe, not to cut you off, but I believe you had two exhibits. Obviously, your Simpson exhibit number one is your own direct testimony, but you had two additional exhibits you had submitted to that end in your request for administrative notice. One of them was the recommended decision in 18280, and then the other one was, which you marked as Exhibit 2, was an application in 24-247-UT. Is that correct?
yes, Your Honor.
Okay, and can you
Yes,
just
Your Honor.
touch on what that is about?
That application is a pending application, has not gone to hearing yet. In fact, I don't think the direct testimony has been filed yet, but it is the same issue. And that application refers to 18-00280.
Okay.
So they're exactly the same issue.
Okay, thank you.
Wait, sorry, but John McCook, here in Sarah Crank, I'm sorry. You said, Mr. Simpson, you don't think that's been filed. I presume what you mean by that is, I mean, you have the document, so that application was filed on e-docket.
Yes,
but
sir.
the pending hearing, that testimony has not been subject to a hearing process. It's just basically attached to the application. Is that what you're saying?
Exactly, sir. That application has been filed, but no direct testimony by interveners or anything has been filed yet.
Because we haven't had a hearing yet.
Correct, sir. I believe that hearing is scheduled for early January.
Thank you.
Thank you, Mr. Simpson. I appreciate that. Let me ask the other parties to this case, starting, I guess, with EPE. Do you have any position on what Mr. Simpson has requested, Ms. Burns?
Yeah, thank you. EPE has no objection to a recommended decision being taken administrative notice of. We would just request that the final order that disposes of that recommended decision, the hearing examiners also take administrative notice of that, just for the rule of completeness.
Okay.
And then I'm unclear on the purpose of an application and attached testimony coming into the record in this case. I don't, EP doesn't really have a position if the hearing examiners want to take administrative notice of a filing at the commission. I just think it would be highly unusual to, subject anyone to cross-examination based on testimony that hasn't been entered into a record. But, Mr. Simpson's pro se, and, I don't really understand what the purpose is of that.
Okay, thank you.
Mm-hmm.
Staff, Mr. Friedman, do you have a position on this?
I think staff will defer to the hearing examiners. Staff won't take a position on it.
Okay.
I'm not too familiar with what's in it, so makes it a little more difficult, I think, to have a position last minute.
Okay. How about any of the interveners to this case? I don't know, Mr. DeSalen or Mr. Herman, if anybody has any, or Ms. Lynch?
Yes, Mr. Hearing Examiner, a couple of thoughts. First of all, we don't have any objection, but I guess I would point out that another way that this could be handled is that Mr. Simpson could use the documents in his cross-examination of the witness. Then we'd all understand what the purpose of using those documents for this hearing, and he could then seek to admit the documents at the conclusion of his cross-examination, which is a typical way of doing it. And you could rule on it at that point, just as an evidentiary matter without necessarily having to take administrative notice of it.
Thank you, Mr. DeSalen. Mr. Herman, anything?
Yes, Mr. Examiner, just maybe more of a philosophical question about the purpose of administrative notice and whether it's necessary for the commission to take notice of its own records. But we don't object so long as, Mr. Simpson lays a proper foundation for whatever questions he's asking. And I think at that time we'll be able to fully evaluate the need or necessity for these documents.
Okay, thank you. And Ms. Simpson, I'm inclined to agree with Mr. DeSaland and Mr. Herman on this. So I think what we'll do is reserve ruling on this particular request right now. So you can bring this up and cross-examination. Let's see where you go with it. And then if you move for admission of these exhibits, then we can handle that at that time. Does that sound fair?
Yes, Your Honor, that sounds great.
Okay, thank you. Okay, so with that, are there any other preliminary matters from the parties that we should address before we begin the evidentiary portion of the hearing this morning? Okay, seeing none. With that, Ms. Burns, EPE, you can call your first witness.
Thank you very much. EPE will call its first witness, Victor H. Silva.
Thank you. And if the court reporter would please swear in the witness.
Mr. Silva, would you raise your right hand, sir? Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Do.
Thank you.
Good morning, Mr. Silva.
Good morning.
Will you please spell your full name for the record? State it and spell it for the record.
My name is Victor Silva, Victor Silva.
Okay. And what is your current profession?
Currently, I am manager of the Energy Efficiency Department
For which company?
for El Paso Electric.
And do you have before you a document which has previously been marked EPE Exhibit 1?
Yes,
Do you recognize that exhibit?
I do.
Can you identify it for the record?
It's the direct testimony of Victor H. Silva on behalf of El Paso Electric Company, dated July 29th, 2024.
And it's also marked corrected?
It is marked corrected.
Okay. And what do the corrections reflect?
These corrections reflect changes to the budget for the Score Plus program for years 2026, 2027.
And they were contained in EP's errata notice that was filed in this case?
That is correct.
Okay. And was this direct testimony drafted by you or under your direct supervision?
Yes, it was.
And are there, on your table of contents, are there any exhibits?
Yes. There's
And
5.
are those exhibits identified on your table of contents part of your direct testimony?
Yes.
Do you have any corrections, revisions, or edits to make to your direct testimony this morning?
No, I do not.
And was that testimony you prepared true and accurate to the best of your knowledge and belief?
Yes.
If I were to ask you the same questions that are contained herein today, would your answers be the same?
Yes.
Okay. I'd like to move what's been marked EP Exhibit 1 into the record as evidence.
Thank you, Ms. Burns. Is there any objection to the admission of what's been marked for identification purposes as EPE Exhibit 1? Seeing none, EPE Exhibit 1 is admitted into the record.
Mr. Silva, can I direct your attention to a document that's been previously marked EP Exhibit 2? Do you have that before you?
Yes,
Do you recognize that document?
I do.
Can you identify it for the record?
Rebuttal testimony of Victor H. Silva on behalf of El Paso Electric Company, dated November 1st, 2024.
And Mr. Silva, is the exhibit that's listed on the table of contents as part of your rebuttal testimony, is that also part of your rebuttal testimony?
Yes.
And do you have any corrections, edits, or revisions to make to your rebuttal testimony this morning?
No, I do not.
If I were to ask you the same questions that are set forth in herein, would your answers be the same?
Yes.
And are the answers true and correct to the best of your knowledge?
Yes.
Mr. Hearing Examiner, I'd like to move what's been marked EP Exhibit number 2 into the record as evidence at this time.
Thank you. Is there any objection to the admission of what's been marked as EPE Exhibit 2? Seeing none, EPE Exhibit 2 is admitted into the record.
Thank you. I'll pass the witness for any examination, cross-examination now.
Thank you, Ms. Burns. Okay, so with that, let's see, on our order of cross-examination, I believe first up is Mr. DeSalen. Do you have any questions for this witness?
No questions, Mr. Hearing Examiner. Thank you.
Thank you, Mr. DeSalen. Next up would be Mr. Herman and Doña Ana County. Any questions for Mr. Silva?
No, Mr. Examiner.
Thank you. Mr. Simpson, that brings us to you. Do you have any questions for Mr. Silva?
No, I do not, Your Honor. Thank you.
Okay, thank you. Ms. Lynch, on behalf of Prosperity Works, do you have any questions for Mr. Silva?
No, sir. Thank you.
Thank you. And last but not least, Mr. Friedman with Utility Division staff. Any questions?
Yes, staff does have questions for Mr. Silva.
Please proceed.
Mr. Silva, good morning.
Good morning.
Can we begin by referencing your rebuttal testimony? Just
Yes.
let me know when you have that pulled up. Specifically page 8, lines 14 through 16 is what we'll be referencing.
Page 8, lines 9 through 14.
Lines 14 through 16.
Lines 14, okay.
If you want, I'll give you a second to read through them so you know what we're talking about.
Okay.
So there you indicate that EPE fell short of what you called, and I'll quote, an average annual goal. Is that correct?
Can you repeat the question?
So I want to clarify your
Okay.
reference to an average annual goal. Starts on line 14 and ends on line 15.
Okay.
And is it correct that you indicated that EP fell short of that average annual goal?
For 2022?
Yes.
Yes, that is correct.
And as a witness in this case, have you reviewed the Efficient Use of Energy Act and the commission rules?
Yes.
And actually, Hearing Examiner Greencamp and Ryan, I'm going to reference part of that statute. Would you prefer me having the witness read the sections that I'm going to ask him about into the record, or would you prefer to just me forgo that and have you guys take judicial notice?
Well, I don't know that we really need to take judicial notice of the statutory provision. I mean, as far as how you handle the cross, whatever is most convenient to you, I think is fine for my purposes, as long as we're clear about which provision in the statute we're talking about.
Thank you.
Before you go and do that, though, Mr. Friedman, I'd like to just ask one clarifying question of the witness. So I believe you're asking him about his rebuttal, page 8, lines, I think he was saying beginning at, there's a whole paragraph from 12 to 16. That's the one you're referring to?
Yes. Great.
Mr. Silva, can you just, I read the testimony and I see what you said there about, this seems to be rooted in some kind of desire to penalize EPE for not complying with the plan year 2022 requirements. And then it says the reasons that you did not comply were outside of EPE's control, namely the COVID-19 global pandemic and supply chain issues. Can you just explain for me a little more how those, I can conjure in my mind lots of, perhaps human behavior changed and therefore that had impact, but it wasn't clear to me from the testimony how exactly the COVID-19 and supply chain issues specifically produced the deficiency.
Yes. So with the COVID-19 pandemic, that affected obviously the whole world and logistics. That was one of the reasons. Another reason was that the final order for the previous case was delayed by 11 months. And so with that said, EP was not able to start their programs. But going back specifically to your question, which is related,
Wait, sorry, so the order from the prior case, so you're referring to 21-154?
Yes.
That order was delayed by supply chain issues and COVID-19?
No, that was another reason why.
Oh, okay. So you're indicating in addition to those, the commission final order, the final order itself took 11 months and that was too long. That was delay.
That did not help us.
Okay. All right. Sorry. Go ahead. Thank you.
Okay. And so with that said, obviously the pandemic, we had supply chain issues, contractors getting equipment, and just overall, it was a difficult time for the country, for El Paso Electric, for our customers, and so it was not the best of moments for our programs.
Okay. Thank you. Go ahead, Mr. Friedman.
Thank you. Mr. Silva, if you can refer to what I've actually marked as Staff Exhibit 8, and the reason I did that was so it was more for demonstrative purposes so people could reference it quickly. And what that is the EUEA, which is 62.17.5.
Okay.
So if you can pull that up and if you can read 62.17.5G.
Let me pull that up. That was a staff exhibit?
Yes, 8.
Staff exhibit 8. Can you repeat which section?
G.
Okay. Public utilities providing electricity and natural gas service to New Mexico customers shall, subject to commission approval, acquire the cost-effective and achievable energy efficiency and load management resources available in their service territories. This requirement, however, for public utilities providing electricity service shall not be less than the savings of 5% of 2020 total retail kilowatt hour sales to New Mexico customer classes that have the opportunity to participate in calendar year 2025 as a result of energy efficiency and load management programs implemented in years 2021 through 2025. No later than June 30th, 2025, the Commission shall adopt through rulemaking energy savings targets for electric utility for years 2026 through 2030 based on cost-effective and achievable energy savings and provide utility incentives based on savings achieved.
And I will just say for the record that if Ms. Hoyman couldn't keep up, it's a challenge with having folks read stuff like a statute. We necessarily want to, our brains want to move through it quickly, and then we speak fast. And it's not a criticism at all, Mr. Silva. I would do the exact same thing. It's just if Ms. Hoyman didn't catch any of that. I mean,
for the record, I can repeat if.
No, that's fine. It was all read correctly. It's just I would just note that you just basically read the text of the statute, and it can be consulted elsewhere to the extent to which there was any inability to keep pace. Go ahead.
In that section, did you see or understand any reference to, and I'll quote in your words from your rebuttal testimony, an average annual savings?
It's not specific to being an average in this text.
So let me clarify. So in your rebuttal testimony, based on the previous question I'd asked, you had wrote that EP did not reach its average annual goal for year 2022. Do you see anywhere in the statutory language that you just read a reference to an average annual goal or savings?
It is not specific to that.
And in the second sentence of 62.17.5G, if you can just look at that sentence and let me know when you're done, I won't have you reread it out loud.
Okay.
Do you agree that this part of the statute articulates a requirement of 5% energy savings based on EP's 2020 retail kilowatt hour sales that EP must meet by 2025?
Yes.
And if you can return back to your rebuttal testimony on page 7, line 10.
Okay.
And there you wrote, and I'll quote, the EUEA established the energy savings targets of 78.87 gigawatt hours for 2021 through 2025, which works out to an average of 15.77 gigawatt hours of savings per year. Did I read that correctly?
That is correct.
And here you acknowledge the 2025 requirement while adding that to meet that requirement, it would take an average of 15.77 gigawatt hours of savings per year, correct?
Correct.
However, we just read a moment ago that the EUEA statute requires a savings of 5% of 2020 total retail kilowatt hour sales in calendar year 2025, not an average savings per year. Is that right?
That is correct.
And if you can refer back to the EUEA statute 62.17.5, but instead of G, we're going to go to H.
Okay.
And for the sake of time, I guess I won't have you read that again. But if it can be just referenced for the record that we're going to be looking at H instead of G. If you can take a moment to read it to yourself, though, so you understand my questions.
Okay.
Would you agree, based on what you just read, that 62.17.5H states that a utility shall propose alternative requirements if the utility determines it cannot achieve the minimum requirements established in statute?
Understood. I agree.
Has EPE reported to the commission that it is unable to meet the savings requirement and proposed alternative savings requirements?
EP has not.
And if you can turn to Staff Exhibit 3. And Staff Exhibit 3 is EPE's response to staff's first set of discovery requests.
Okay.
And if you can refer to 1-4.
All right.
Are you the sponsor for the response of 1-4?
Yes.
Do you need a moment to reference it, to look it over, or are you familiar with it?
Provide me a moment just to refresh my memory.
Sure.
Okay.
Do you agree that EP's response to staff's discovery question 1-4A indicates that EPE has not filed a variance request in reference to the projected shortfall in meeting the EU EA requirements?
Please repeat that question.
Sure. So would you agree that your response in that question indicated that EPE has not filed a variance request in reference to the projected shortfall in meeting the EU EA requirements?
Yes, I agree.
And do you agree to EP's response to question 1-4B? So that's the second sub-question there. Beginning at the second sentence in paragraph 2, which states EPE is highly optimistic that it will be able to meet or exceed the EU EA requirements with additional oversight of current and proposed programs performance, and then it goes on.
Okay.
Would you agree that that's what is written there?
Yes, it is.
And if you can turn to your direct testimony, I know we're jumping around a bit.
Okay.
Go to page 11, and you'll see a table that you drafted there on page 11. I'm sorry, I didn't hear you.
I see it.
Okay. So there is table 2, which is labeled as savings goals. Is that right?
That is correct.
Would you agree that if this table is correct, then based on the information you've presented in it, that the company would need approximately 18.8 gigawatt hours of savings in 2025 to meet the EU EA requirements?
Can you explain where you're getting the 18.8? Just, I do have a number in my mind, but I want to see where you're getting the 18.8.
Excuse me, Mr. Friedman, what exhibit are you referring to? Or what page of the direct testimony?
Sure. So it's EP Exhibit 1, direct
Uh-huh.
testimony of Mr. Silva, and we're looking at page 11. And on page 11, there's a table 2 regarding EP savings goals.
I do see it. I just want to clarify the exact number.
Sure. So the number I'm referencing is not in your table.
Right. Okay.
So you won't see it there.
But I think
So I guess
essentially,
go ahead. Sorry.
I think essentially you're trying to get the difference, correct?
Yeah, I'm trying to determine how short EPE's savings goal will be of that is required.
Understood. And what is the question?
So based on the information you've provided in that table, would you agree that EP would need approximately 18.8 gigawatt hours of savings in the year 2025 in order to meet the EUA requirements?
Yes. That's an approximate figure, but yes.
And based on your table, which portrays EPE's historical savings and the company's own projected savings for 2024, and the company's response to staff's discovery question 1-4, is it fair to say that EPE is highly optimistic that it will achieve a savings of at least 18.8 gigawatt hours by 2025?
Yeah.
And if I can direct you now to Staff Exhibit 2, which is the direct testimony of staff witness Dr. Watara.
Okay, I have it.
Mhm.
And if you can turn to page 11, lines 3 through 12. And you can read those.
Okay.
So based on what Dr. Watara wrote, do you agree that he recommends EP's baseline incentive begin at 19 gigawatt hours?
Are you asking me if I agree or do I understand?
If you agree, that's what's recommended.
I can say I understand what he's why he would recommend the 19 gigawatt hours.
Would you agree that that number is suggested because it's approximately 19 gigawatt hours based on EP's projections for the level of savings necessary to meet the EUEA requirements?
Yes.
I'm good. All right.
And if we can return back to your direct testimony, we'll look at page 11 again, and lines 1 through 9 is the table.
Okay.
Reviewing that table, do you agree that it's consistent with Dr. Watara's observation that EP would need to achieve approximately 19 gigawatt hours of savings to meet the EUEA requirements?
I'm going to object. I think the question's been asked and answered already by Mr. Silva.
Mr. Friedman, any response?
I'm trying to make it as clear as possible, but if I can definitely move on without this question. So
I think I agree with Ms. Burns, so I would suggest that you move on.
okay, Mr. Silva, if we can move to page 8 of your rebuttal testimony. Apologize.
Okay.
And on lines 14 through 16, you indicate that EPE fell short of what you call an average annual goal. Is that correct?
That is correct.
So
All right, Mr. Freeman, so could you point me to that page again real quickly?
Sure, hearing examiner Ryan. It's page 8, lines 14 through 16. And that's rebuttal
Gotcha.
testimony.
Yep. Just want to make sure I'm following along.
So you've provided no reference for the establishment of an average annual goal. Are you able to provide a reference for when the commission authorized an average annual goal as opposed to the 2025 requirement of 5% of 2020 sales established in the EUEA?
No.
Can you direct me to any approval of an average annual goal as a substitute for the 2025 requirement of savings of 5%? of 2020 sales that is established in the EUEA or in the commission's rules?
No.
And can you direct me to any approval for an average annual goal as a substitute for the 2025 requirement of savings of 5% of 2020 sales in the recommended decision or the order adopting the recommended decision in case number 21-00114-UT?
No.
Mr. Silva, this is my last question. To your knowledge, is the average annual goal that you referred to established anywhere in the commission's rules or the EUEA?
Let me see if I understood that question correctly.
I can rephrase it as well if you'd like.
Please, thank you.
So your reference to the average annual goal, is there anywhere that's referenced in the commission rules or statutes?
No.
I have no more questions at this time.
Great. Before Mr. Friedman, this isn't. I'm going to ask you some questions that are not evidentiary in nature. I just want to make sure I understand the obvious. What you're doing is trying to elicit some facts in support of a broader legal claim, which is where you started with the statute. So again, and if to the extent to which Ms. Burns wants to chime in a bit, I'll happily hear from her. So my understanding, Mr. Friedman, what you're saying is the statute required them to supply notice to the commission that they weren't going to be able to meet their requirements. It appears they didn't do that. And the discussion you've just had with Mr. Silva seems to indicate that the company has identified a target that doesn't seem to be, really have a source in anything. That was the nature of your last question. Is my understanding correctly what I've just heard?
Yes. Yes, it appears that EP relies on, in their words, an average annual goal. And it's staff's understanding that it should be relying on the statutory language. So that's the point we're trying to.
Yeah.
to be
Okay.
clear.
No, and I understood that's what you did there. And so I guess my question to you is, they identify reasons as to why the short fall exists. And if I understand the testimony, they're saying, it's outside of our control, and therefore to require us to have some makeup is not correct. I guess my question is, and this will be a briefing question ultimately, but as a preliminary matter, and we're here in a factual hearing, and I want to make sure we have all the right facts. What's in staff's view, what's the mechanism that they're supposed to, be relying on or utilizing to make up a shortfall if such a thing happens and for reasons that are outside of their control?
Sure. So my understanding of this is a little more limited than actual staff. So when they get up, maybe they to the testify, they might be able to clarify better than myself. But it's my understanding that 62, hold on one second. It's I want to make sure I'm referencing the statute correctly.
17.5.
62-17.5, establishes what is required by the electric utilities, right? However, if that goal, or if that requirement rather, is not achieved, subsection H has an avenue for which the company can essentially seek a variance. And it's staff's understanding that EP has not done that.
And so with Dr. Watara's testimony, then which I've also read, staff's position is that they should have a larger obligation to make up for the shortfall.
That's my understanding, yes.
And staff's conclusion that that's appropriate has its foundation where in the statutes or the statute? And if the answer is it's just implicit because there's a target and then, you know, they don't meet it, that's an answer. I understand if that is your answer.
Well, so in subsection G, it outlines the requirements for public utilities of 5% for 2020 of the retail kilowatt hour sales. And it's my understanding that that is not the standard for which EP is relying on they're not relying on that language. Instead, they've determined this average annual goal language in its place. I hope that's more clear.
No, I understand your answer. I mean, I think we can speak more about it, but I think understand the chain of thoughts that leads to where you're going.
And I'm sure staff witnesses would be able to make that a little more clear from their expert knowledge than perhaps I can.
Sure, and my goal in all of this discussion here is not to elicit facts from you, is more to just understand your position so that when the appropriate witnesses are there, we can ask them the questions. Ms. Burns, any follow-up you want to give based on the questions or the discussion I had with Mr. Friedman?
Sure. I would just like to point out that I think there is probably some confusion regarding the statutory goal and the baseline for the utility incentive. So there is a annual average utility baseline incentive that was set in the last case. You know, and I understand there could be some confusion, you know, whether or not the savings goal is an annual average or the total, but EPE understands that it's a cumulative 2025 goal. So.
Okay. That was it for me.
Okay. Well, I believe, Mr. Friedman, you've concluded your cross-examination with Mr. Silva?
Yes.
Okay, thank you. And that is all of the parties, I think. Hearing examiner Ryan, do you have any questions for Mr. Silva?
Yeah, I just one really. So this is just the app. I just want to make sure I understand the bill impacts of the proposal in the application itself. And I loathe to, it's what is this document? It's paragraph 18 of the application. So 24,00154 of the application. And then if you go to page 7, paragraph 18, it says, if this application is approved, a typical residential customer would be looking at $2.66. And then and I'm just trying to summarize here so the court reporter doesn't have to write a lot. So then it says this is an increase of 39 cents over the current EU ERF charge of $2.28, or a 0.6 increase relative to the current bill. And my question was going back to 21,00114 and the like just thinking how much the increase was from that case to this present one. Do you know the cumulative bill impacts, Mr. Silva? Because that seems like if I remember correctly from what I read in 21,114, the actual bill impact was a little bit larger than this, though not terribly significant. It was a small increase. And I'm just wondering if that means you would add the 0.6 to what the last increase was. Just want to confirm that.
I guess, Mr. Hearing Examiner, I think that's a better question that could be addressed by witness Hernandez. He does have some exhibits. I believe there were some corrections. To provide you the most up-to-date information, I would refer that to witness Hernandez.
Okay, yeah, no, it's just to be clear, it's page 4 of the recommended decision in 21-00114, where it says that the increase there would have been a 1.5% increase on the monthly bill. So I just wanted to confirm that all total will be 2.1%. But I will ask Mr. Hernandez that question.
Anything further here, Examiner Ryan?
No, thank you.
Okay. And Mr. Silva, good morning. I think I only had one question for you. My question relates to page 19 of your, I believe this is your direct testimony. You're asked about the avoided emissions benefit in the utility cost test. Again, that's page 19 of your direct testimony. Bleeds, I guess, into page 20. And I just wanted to better understand this because I know that staff has expressed some concerns. And so you're asked this question, why EPE is proposing commission approval to include this avoided emissions benefit in the utility cost test. And you referenced this EPA supplementary material or supplementary guidance. My understanding is this is a new, this was not something that EPE had proposed as part of its previous case. Am I to understand that the reason behind the impetus, I guess, behind bringing it forward in this case is this supplementary guidance from the EPA? Do you understand my question?
Yes, thank you, Mr. Herring Examiner. I think that was one of the reasons. Another couple of reasons were recommendations by stakeholders. Philip Simpson, in particular, our statewide evaluator, also had some input there. And so those are a few reasons why we decided to go with or include the avoided emissions cost in this UCT.
Okay. I don't think I have any further questions.
Well,
Ms. Burns?
I did, sorry, before going to Ms. Burns, just one thing I did mean to ask, and as you were talking, occurred to me. Maybe Mr. Silva, I'm not sure if he's the right person to answer, but we'll see. Mr. Silva, and this is a legitimate question I'm asking, trying to, gotcha or anything. If I understand correctly, the proposal here is to reduce the budget for those low income programs. Is that right?
I think the initial proposal was, we did change it in my rebuttal testimony. We increased those budgets back to 2024 levels for years
Okay.
2025, 2026. And
Oh.
for 2027, we did our best, trying to be within under the 5% rule of our 2020 revenues. Your initial
Yeah, go ahead. Sorry.
your initial comment is accurate, but in rebuttal testimony, we reverted back to 2024 levels for low income.
And was that because of some of the interveners kind of had sort of challenged that? Was that the idea?
Yes.
And now, more than anything, I was just curious, what was the thought behind the initial reduction in the budget for the low income? Was it just because the programs are not being used, or?
When the budgets were being created earlier this year, we looked at participation levels. And so, and we also looked at any other potential programs that and measures that we could have added to increase the savings for our portfolio. And so one of the determinations that I had made was reduce some of these programs so we can bring on some other programs and, some other measures. And that's what we did.
And just so I understand what you said there, so reduce the specific low income programs that EPE had in place, and are you saying to then maybe perhaps do some utilize other programs that would be more effective? Is that the idea?
That we would be able to claim more savings, knowing the challenges that we have to meet the EUEA goal.
And then, and it's the reason why you'd have more savings is because you'd have more robust participation with other
Yes.
programs. Is that okay? What I'm trying to figure out is, the low income issues. Look, they're constant, and we have a unique situation in this state given the socioeconomics that we confront, and it's not just EPE, it's also P&M and SBS to a lesser degree. But I think it's just, what's the lessons learned for encouraging low income participation in these energy efficiency programs? I'm asking that as a question if you have any answers.
I think so. Let me step back a little bit. When that budget was initially, when we came up with that budget initially, we did look at the participation levels. Also, given the challenges that we have for meeting the EUA goal, we had to make a determination what was best at that time. Also, being within the 3 to 5% of our 2020 revenues. When the RFI came in the recommendation to increase those back to 2024 levels, we looked at the budget and we saw that there was an opportunity to still be within the 3 to 5%. And so that's why we changed it back. And EP agrees that, the more we can do with low-income households, the better. But it's a balance that we have to make to try to see what's the best for everyone, for EP, for the customers, and stakeholders.
Okay, thank you.
Ms. Burns, any questions on redirect?
Yes, I just have one series of questions on redirect to clear up the record. You've changed places, Mr. Silva, on my screen. Do you recollect someone, I think it was, I can't remember who it was asking you about EPE's prior, most recent energy efficiency and load management case docket number, and that was filed in 2021, correct? Do you recall? I don't know if you recall that question. And they had referenced a 21-00154 UT docket number. Do you recall that question?
As part of a correction to an RFI, Nancy?
No, you were getting asked a series of questions, and there was a reference made to EPE's prior energy efficiency, most recent 3-year plan docket. And the question asked was, that was filed in docket 21-00154-UT, correct? And you had responded correct. Do you remember that question and answer?
I don't recall that off the top of my head right now.
Okay. Do you recall, are you familiar with EPE's last 3-year plan docket number?
Generally, I'm familiar.
Do you know what that docket number is? For its 2021 case?
Yes, I should have it here somewhere.
Yeah, just if you could just cite that to clarify the record.
Okay. Yes, that was EP docket 21-00114-UT.
Thank you very much. I have no further redirect.
And that was
Thank
probably
you.
my error, Miss Burns. That was I was asking those questions. Did I call it 21-154, which is sort of both of
I th-
these?
I thought that I had heard 114, but I could have misheard. I had it written down. But in any event, I appreciate the clarification. Okay, so with that, are there any questions on recross from any of the parties? Seeing none. Anything further, Hearing Examiner Ryan?
Nope.
Okay. So with that, Mr. Silva, thank you very much for your testimony today. We appreciate it. And you
Thank
are
you, Mr.
released.
Hearing Examiner and everybody.
If we could just take a brief bio break, Hearing Examiner Krankamp, I'd appreciate it.
Yes, so why don't we come back in 10 minutes? So at about 10:45, we'll come back. And for now, we're off
Terrific.
the record. Thank you. Okay, it's 10:45. Do we have most people back at least? Do we have Ms. Burns? Thank you. Ms. Hoyman?
Yes, Mr. Hearing Examiner, if you would give me just 1 second, I'm sending a message to Hearing Examiner Ryan.
Yeah, absolutely.
Thank you. It'd just be 1 second.
Okay, no problem.
Thank you, sir. I'm ready.
Okay, sounds good. And I see, looks like we're ready. Okay. So we are now back on the record. The time is 10:45 a.m. And we had just finished with the testimony of Mr. Silva. And Ms. Burns, if you are ready to call your next witness, please go ahead and do so.
Thank you, Mr. Hearing Examiner. EPE calls Derek Newman.
Thank you. And if the court reporter will please swear in the witness.
Mr. Newman, would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Mr. Newman. Will you please state your full name and spell it for the record?
Good morning. Yes, it's Derek Newman, Derek Neumann.
Mr. Newman, what is your current profession?
I'm a senior engineer with Frontier Energy.
And do you have before you what has previously been marked EPE Exhibit 3?
I do.
And do you recognize that document?
I do.
Can you identify it for the record?
Sure. It's my prepared direct testimony in this case. It's titled Direct Testimony of Derek R. Newman on behalf of El Paso Electric Company. And it's dated July 29th, 2024.
And it's marked corrected, isn't that true?
That's correct.
And the corrections incorporate the corrections of EP's erratus notice filed in this case. Isn't that correct?
Correct.
And was the direct testimony that you've just identified drafted by you or under your direct supervision?
It was.
And is there an exhibit listed on your table of contents?
Yes, Exhibit DRN 1.
And is that part of your direct testimony?
It is.
Do you have any corrections, edits, or revisions to make to your direct testimony this morning?
No, not for this exhibit.
And was the direct, if I were to ask you the same questions that are set forth therein today, would your answers be the same?
They would.
And are they true and correct? Are those answers true and correct to the best of your knowledge?
Yes.
Mr. Hearing Examiner, I'd like to move what's been marked EPE Exhibit 3 into the record as evidence.
Thank you, Ms. Burns. Is there any objection from any party as to the admission of what's been identified as EPE Exhibit 3? Seeing none, EPE Exhibit 3 is admitted into the record.
Thank you. Mr. Newman, do you have before you what's previously been marked EPE Exhibit number 4?
I do.
Do you recognize that document?
Yes, I do.
Can you identify it for the record?
Sure. It's my rebuttal testimony. It's titled Rebuttal Testimony of Derek R. Newman on behalf of El Paso Electric Company. It's dated November 1st, 2024.
And are the exhibits, the two exhibits listed under the table of contents of that rebuttal testimony part of your rebuttal testimony?
They are.
Do you have any additional edits or corrections to make to your rebuttal testimony this morning?
I do. I have one correction to my exhibit DRN 1R on page 40 of 97. Under the final paragraph, there's a section titled Participation Requirements. So in that section, on the third row, there's a correction from IECC 2018. to reference the current New Mexico Code IECC 2021.
Okay, and that's marked on your rebuttal testimony, correct?
That's correct.
All right. Do you have any further corrections to make this morning?
I don't.
If I were to ask you the same questions that are set forth in here, Heron, would your answers be the same?
They would.
And are your answers true and correct to the best of your knowledge?
Yes, they are.
Mr. Hearing Examiner, I'd like to move what's been marked EPE Exhibit Number 4 into the record as evidence.
Thank you. Any objection to the admission of EPE Exhibit 4? Seeing none, it's so admitted.
Thank you. So I would like to pass the EP's witness for cross-examination and examination at this point.
Thank you. Okay, let's see. First up on my list, I have, I believe, Mr. DeSalen with CCAE. Do you have any questions for Mr. Newman?
No questions, Mr. Hearing Examiner. Thank you.
Thank you. Let's see. Next up, I do not see Mr. Herman, so I go to Mr. Simpson. Sir, do you have any questions for Mr. Newman?
No, I do not. Thank you.
Okay, thank you, Mr. Simpson. Ms. Lynch, any questions on behalf of Prosperity Works?
We do not have any questions. Thank you.
Thank you. And finally, Mr. Friedman, any questions from Utility Division staff?
No questions.
Okay. No questions from the parties. Hearing Examiner Ryan, do you have any questions for this particular witness?
Sorry, to my audio back on. Just one, really. Mr. Newman, you note the saturation points for evaporative cooling in Epe'S service territory, and I guess I'm wondering, in more just my own edification than anything, I suppose, efficiency-wise, the evaporative cooler, which I understand is colloquially referred to as a swamp cooler, is that right?
That's right.
What is their efficiency in comparison to a heat pump air conditioning unit?
So from my understanding, and I will say I'm located in Austin, Texas, where we don't really have evaporative cooling, but the primary savings benefit is not necessarily from higher efficiency, it's from a much lower consumption. So by installing an evaporative cooler in lieu of an air conditioner or a heat pump, it will operate at a much lower consumption by comparison.
Electricity consumption.
Electricity consumption, yes.
And that just reflects the fact, I'm assuming, that I mean, you're just blowing water over air over water, and that's what's providing the cooling rather than any sort of chemical process that has to do with the heat pump. I mean, would that generally be the case?
Yes, that's correct.
Okay, that was all. So I mean, in the end, the saturation point of evaporative coolers in EPE, it's not a problem. It's not as if some other technologies there that's going to be more efficient. I mean, what sounds like what you're saying is that's actually the most efficient.
When you're referring to saturation point, are you referring to
the number of them?
Number of them? Yes.
Yeah, I mean, that's why I just thought it was. I read the statistic you gave and it was surprised like that many folks have evaporative cooling down there. But I guess that makes sense. It's actually the way to go.
And EPE does offer a very good incentive to try to keep customers on evaporative cooling instead of converting to refrigerated.
Gotcha. Thank you.
Thank you.
Good morning, Mr. Newman. I too only have really one question for you. I just want to make sure that I'm understanding table 4 of your direct testimony. I believe it's on page 15.
All right, I'm there.
Yeah, and if I'm understanding this table correctly in terms of what its function is, essentially you're analyzing the cost effectiveness of these various programs within EPE's portfolio. Is that correct?
That's correct.
Okay. And so each year there you have, for 2025, 2026, and 2027, you have two different, I guess, standards. One of those is including this carbon emissions benefit, the proposal for that. And then essentially how cost effective it would be without it. Am I understanding that right?
That's correct. Without the benefit, that's the columns labeled standard, and with the benefit, it's labeled with emissions.
Okay. So for instance, if we look at, let's say, just because it's first, the Smart Students program, and the numbers I think are all the same between 2025 and 2027, without the inclusion of that additional benefit, essentially it has a benefit cost ratio less than 1 of 0.75, right? So then it would not be cost effective, but with the inclusion of that additional benefit, that program that becomes cost effective under your analysis. Is that a fair summary of what this table shows?
Yes, that's correct.
Okay, perfect. I just wanted to make sure I understood that.
And can you explain, Mr. Newman, like how does that work exactly? So you 0.75 for the Smart Students in 2025, but then if we fold in that avoided emissions benefit, it goes to 1.33. Can you explain why is that?
So the cost effectiveness calculation at the highest level is a comparison of the benefits to the costs. And so in this case, under the standard UCT test, the benefits are calculated assuming the avoided costs associated with the energy and demand savings. So with the inclusion of carbon emissions benefit, we'd be adding an additional offset cost for the carbon emissions. That's essentially an adder to the existing avoided energy cost because they're both specified in terms of dollars per kWh.
And then, and I understand that at that highest level, more granularly within the Smart Students program, maybe can you explain how it makes sense that you would look at avoided emissions? Like, how does that fold into the Smart Students program in a way that's coherent?
Sure. So, we're talking about the Smart Students program here as an example, but really any program that delivers energy savings would be impacted similarly. Another good example to maybe point to might be the residential or commercial load management programs. You can see that those programs do not see as significant a change, and that's because they're primarily demand-driven programs. So again, any program that has an energy savings component would be impacted by this because the benefit is specified in terms of dollars per kWh.
Okay, I guess I have to go look through the testimony to just better understand. And I'm trying to remember what the specific. Could you just remind me the Smart Students program attempts to achieve what?
That's a educational kit-based program, various energy efficiency measures and some behavioral educational information is distributed to students in elementary and high school classrooms.
And so when we think about an avoided emissions benefit to those students, how does, I guess I'm just not understanding what about avoided emissions benefits students? I mean, apart from, all the costs to us as externalities and the varying problems we encounter in society, Spain, right? The floods and all that.
Sure. Yeah, so the emissions benefit are not really tied directly to any specific program delivery. If I pointed to my response to question 12 on page 7 of my direct testimony. I define the inputs that were used to quantify that offset emissions benefit. Specifically, the emissions rate comes from EPE's 2022 Corporate Sustainability Report, and then the social cost of carbon comes from the EPA's 2023 report on the social cost of greenhouse gases. So Frontier was not directly involved in defining these inputs or defining the resulting metric for the offset emissions benefit. That was provided from a memo from EPE's statewide evaluator, but it is quantified here. You essentially just multiply those two values against one another, and then you get a resulting value of $29.37 per megawatt hour, which is just under 3 cents per kWh. So that is then the metric that is added on to the avoided energy cost that results in the higher UCT with its inclusion.
Okay, I understand your answer. Thank you.
Mr. Newman, I appreciate your testimony. Your answers have sort of created another question in my mind. Just so that I, again, am understanding what this table is showing. Let's, for instance, compare the Smart Students program. You see that there's that difference that essentially it's has a benefit cost ratio of 0.75 under the standard test. And then when you include this additional benefit, it goes up to 1.33, which would show that it's cost effective. And then you go, let's say, to the Energy Smart program, which has a standard, under the standard test, it has a ratio of 1.49, and then that goes up to 1.97 with the emissions, with the inclusion of the emissions benefit. When you are coming up with those numbers, are they looking to the contents of that program in terms of trying to figure out how much energy would be saved under that program? I'm trying to understand sort of, again, the input into, how exactly you arrive at those numbers. Do you understand the question I'm asking you?
Sure, I think so. Yes, so when we're calculating cost effectiveness at the program level, each individual program has its own set of assumptions, including expected participation levels, largely driven by historical performance or other implementer or utility feedback that was provided to us, as well as energy and demand savings estimates. You asked specifically about energy because that's what's affecting the emissions offset. But so each set of energy savings, again, we typically define based on historical averages. Most measures have several different inputs that could lead to varying energy savings on a per project basis. All of those savings, those energy savings, are informed by the New Mexico technical resource manual, as long as that measure exists in that document. And then if a energy efficiency measure does not exist in the New Mexico TRM, it may be sourced from some other TRM.
Okay. And I'm assuming that when the assumptions that go into this, these calculations, you touched on, for instance, if the program is fully subscribed, in terms of its participation level, is this essentially the numbers that would exist if the programs are essentially there's full participation?
That's
or
correct.
is this okay? So it's the full participation and not, let's say, an average of possible outcomes of participation, something like that.
That's right. This would be assuming the full budget is exhausted.
Okay. All right. And then one last question. Just this, I think this may be an error, but I could be wrong. If you look at pages 13 and 14 of your direct testimony, on page 13, I see table 1 and table 2. And then on page 14, I see table 2 and table 3. Should that be tables 1, 2, 3, and 4? Or am I misinterpreting that?
It looks like table 2 I'm just double checking a couple of values here, but it looks to me like table 2 is duplicated. So it should be, they're labeled correctly as tables 1, 2, and 3, but the second instance of table 2 should not be there.
Okay. Well, because the way that I'm seeing it, it looks like
it
looks like the numbers are different.
Sorry, I didn't mean to interrupt you there.
No, please go ahead. I was just noting that it looked to me like the numbers are slightly different between those two tables.
Yes, I apologize. The first few values that I looked at were the same. So if you give me 1 second to pull up my source document, I should be able to tell you which table is correct.
Okay, no problem.
Okay, I have it up in front of me. I just need to compare the tables now. So this could require some additional investigation to answer completely. What I'm seeing in my source document is that I believe.
Well, I'll tell you what. I'll tell you what, because I don't want you to have to answer. And I don't know how time sensitive this question is. Ms. Burns, I think maybe one way to handle it is just to treat this as a bench request. If you could just get back to us with at some point which of these two tables is the correct one for us to look at. Would that be a reasonable way to move on?
Certainly. I think it has to do with the errata and the corrected page. And so we'll get back to you on that. Thank you.
Okay, that sounds good. I just don't want to hold us up. But that's all the questions that I have for you, Mr. Newman, and I do appreciate your testimony today. Hearing Examiner Ryan, do you have any final questions?
No, I just would note that, going back to Mr. Newman, when you refer to source document, are you referring to the original submission with the application, your original testimony as initially filed?
I was referring to the Word document that I used to prepare the testimony. It looks like the tables are in a different order in this in the PDF version that I have in front of me. So that's why I was having a difficult time answering the question.
All right, I just went back into the application and it has like table 2 on page 13 of your direct in the application has like a total annual cost for 2026 total portfolio budget doesn't match either of those two tables there. It's like a different number.
So I'm happy.
Yeah.
I was going to try to speak to that. In the version that I'm looking at, the total annual cost for 2025 is $6,794,712, which is not aligning with these values. So I think it's probably most likely what Ms. Burns was referring to, and it's related to the errata, and it looks like the corrected tables may not be displayed accurately in this version.
That's fine. I just making note of
Yeah.
that fact.
And I think just the simplest way, just Ms. Burns, if you just essentially, if you want to just treat the bench request as essentially the updated or final version of whatever that table 2 is supposed to display. And then you can just, rather than tell us which one, just give us that table. And with that, Ms. Burns, do you have any questions on redirect?
No redirect, thank you.
Okay, thank you. And any questions on recross from any of the parties that were spurred by the questions that we asked? Okay.
Your Honor, I do have a question.
Okay, go ahead, Ms. Lynch.
Just because I want it to be comprehensive, but Mr. Newman, are all the tables affected by the changes being contemplated in the bench request, or is it only table 2?
To me, it looks like all 3 tables may need corrections.
Okay.
So hearing examiner Krankamp, well, here's what I was going to suggest. Rather than, I understand the sort of more limited bench request, but if that's the answer, what I think needs to happen is that we need to have new testimony supplied that gives us the correct stuff. I mean, that's kind of vague, I know, but my suggestion is that Mr. Newman resubmit his testimony. If more than just one table is problematic, as Ms. Lynch's question just indicated, and the answer was yes, we should probably just update it to have everything correct.
I would agree with that, and thank you, Ms. Lynch, for catching that. Yeah, Ms. Burns, is it possible for you to file essentially an amended version of what's already been admitted as EP Exhibit 3?
Yeah, that's fine. I would just point out, and I'm sure everyone is aware, that'll be our direct testimony. I think there's additional changes in the update, in the rebuttal, but we're happy to do that.
Okay.
Well, and I guess, Ms. Burns, if there's any other problems that appear in the rebuttal, you can just check that, and then we'll just make sure it's all correct. That's all.
Yeah, if you need to file an amended version of Exhibit 4, then please do so.
Will do.
Okay, thank you. And thank you, Ms. Lynch, for catching that. Any other questions from anyone else?
I have one question on the same topic. When that updated testimony is filed, will interveners have the opportunity to respond if necessary?
Yes, I think so.
Yeah.
Thank you.
May I clarify one additional part of my previous answer?
Sure, please, Mr. Newman.
So if you refer to EPE Exhibit 4 in DRN-1R on page 8 of 97, and I guess I should actually refer first to the previous page, page 7 of 97. The costs reflected in this table and tables 1, 2, and 3 all match what I have in what I was referring to as my source document for my direct testimony. So these are the correct tables. What's referenced in DRN-1R, tables 1, 2, and 3. So that's what should have appeared in my direct testimony.
Okay, so this is in your rebuttal testimony.
That's right.
DRN 1R, pages 7 and 8.
That's correct.
Okay, and your testimony here today is that essentially the testimony that was listed in your direct on pages 13 and 14 should be essentially amended just to reflect what's in your rebuttal testimony.
Yes, that's right.
Okay.
There were some differences that occurred from the direct testimony to the rebuttal testimony. So the numbers, we would expect them to be different. I just am not able to say for sure which of those tables was included incorrectly.
Okay. Okay. Well, I think given that the information is in the record, I don't know that we necessarily need to amend the direct testimony since the rebuttal testimony is there in part to correct that error. Is there any objection from any of the parties if we proceed that way, as essentially not requiring EPE to file anything else, that we're going to treat the rebuttal testimony as a correction on that end? Ms. Lynch, any objection?
I just note that there are different columns in the original direct testimony tables. If the rebuttal testimony gets to the information that's needed and required for an objective decision, I have no objection, but I'm not, right now, I'm just pointing out that difference and I'm unclear.
Not clear. This is confusing.
Mr. Newman, do you see what she's getting at there in terms of the distinction between those tables in the rebuttal and then in the direct?
Yes, the tables that I'm referring to contain the costs, the incentive costs, the administrative costs, and the total annual costs. The original tables that I was first asked about also include participants, annual KW, and annual KWH. Those values are all should be included in my rebuttal testimony as well, but it would not be difficult for me to be able to provide the updated tables if that's desired.
I would like to see those participant and annual kilowatt hour and kilowatt savings in the updated tables.
I will say, just to Mrs. Burns' point earlier, the direct testimony, the correct values at the time in that document was filed may not necessarily reflect the updated values in my rebuttal testimony that incorporated the adjusted budgets for the Energy Saver and Energy Smart program.
If I may.
Please, Ms. Burns.
Yeah, I suggest that we just proceed with the hearing examiner's, initial bench request, which is to update the entire document so that we have the correct direct testimony exhibits in there.
Yeah, I think I agree with that. I think I agree with that, Ms. Burns. So what we'll do, and this is to Mr. Friedman's point, so we'll treat it as a bench request to provide updated tables 1, 2, and 3, based on the information available to EPE as of today. And to the extent that a party feels the need to provide any rebuttal evidence or request to be heard on that, then they can make the appropriate filing following the submission of the bench request. Is that satisfactory, Mr. Friedman?
Yes.
Okay, thank you. Ms. Lynch, is that acceptable to you?
Yes, it's a good fix. Thank you.
Okay, thank you. And Mr. DeSalen, I don't want to leave you out. Anything you want to be heard on this?
No, Mr. Hearing Examiner, I think that the resolution that you have selected will work fine. Thank you.
Okay. And Mr. Simpson?
No problem with that resolution, sir.
Thank you. Okay, so then we'll proceed that way. I don't believe there are any further questions for you, Mr. Newman. Thank you very much for your testimony. We do appreciate it.
Thank you.
And you may be excused. Okay. So now, Ms. Burns, I believe you have one final witness to call.
Yeah, we do, and we're going to change counsel real quick.
Okay.
Good morning. My name is Angela Harris. I'm counsel with Nancy Burns for El Paso Electric Company.
Good morning, Ms. Harris.
Good morning. We'd like to call Mr. Adrian Hernandez.
Okay, and if the court reporter will please swear in this witness.
Mr. Hernandez, would you raise your right hand for me, sir? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Thank you.
Please proceed, Ms. Harris.
Mr. Hernandez, will you please state your full name for the record and spell it?
Yes, my name is Adrian Hernandez. It's spelled ADRIANHERNANDEZ.
Thank you. And what is your current profession?
I'm a principal analyst with the rates department here at El Paso Electric.
Do you have before you what has previously been marked as EPE exhibit number 5?
I do.
And do you recognize that document as the pre-filed direct testimony that you submitted in this case?
Yes, ma'am.
Was that direct testimony drafted by you or under your supervision?
Yes, it was.
Are there exhibits identified on the table of contents as part of your direct testimony?
Yes.
How many exhibits are there?
In my direct testimony, I had 6 exhibits.
Okay. And do you have any corrections to your testimony?
I do not.
Is the direct testimony that you prepared true and accurate to the best of your knowledge and belief?
Yes.
And if you were asked these same questions today, would you give these same answers under oath?
Yes.
Mr. Hearing Examiners, El Paso Electric offers EPE exhibit number 5 along with accompanying exhibit.
Thank you, Ms. Harris. Any objection to what's been offered for admission as EPE Exhibit 5? Seeing none, EPE Exhibit 5 is admitted into the record.
Thank you. Mr. Hernandez, do you have before you what has previously been marked as EPE exhibit number 6?
Yes.
And do you recognize that document?
Yes, I do.
Is this the rebuttal testimony drafted by you or under your supervision?
Yes. Yes, it was.
And are there exhibits identified on the table of contents as part of this rebuttal testimony?
Yeah, there's 2 exhibits. Yes.
Okay. Do you have any corrections to your rebuttal testimony?
I do have a correction. And I apologize for this. I think very late in the process, I discovered that the one of the carrying charges, one of the treasury rates that I used for 2022, I used the 3-year rate instead of the 5-year rate. And so that will obviously cause my exhibits to change. It won't be material, but it will cause a lot of numbers within both exhibits to change.
Okay. So, Mr. Hearing Examiners, EPE became aware of this. Staff brought this to our attention late Friday afternoon after we had already uploaded our exhibits. As Mr. Hernandez said, the change is not material, it's minimal, but if it's acceptable, we can walk through the changes to at least the first page of AH1R now verbally, if you would like, and then we can supplement the record with the corrected exhibits as soon as you would like. We're prepared to do that.
Any objection to proceeding that way from any of the interveners or staff? All right, seeing no objection, yes, please proceed, Ms. Harris.
Sure. Mr. Hernandez, would you walk us through the corrections that need to be made on page 1 of 3 in exhibit AH1R?
Yes. On line 10, the carrying charges should say, instead of 109,525, it should say 115, comma 431. So 115,431. That would cause line 11 to change to 2,000,000, well, I'll just say the numbers. 2,032,668. And then that will change line 13 to 1,016,334. And then on line 19, that percentage will change slightly. It'll change from 0.6832. It'll change to 0.6852. So then the overall EUERF that's being proposed is going to now change to 3.7528. And then we can make the same change on line 15 because that's also showing the proposed EUERF 3.7528.
Okay, thank you. So with the aforementioned corrections, is the rebuttal testimony that you prepared true and accurate to the best of your knowledge and belief?
Yes, it is.
And as I mentioned, EPE will provide updated exhibits as soon as the hearing examiners would like. We can email those out, whatever your preference is.
My preference would be twofold. One, email them to the parties, please, but then also upload the corrected exhibits to Dropbox.
Will do. Mr. Hernandez, if you were asked these same questions from your rebuttal testimony today, would you give the same answer under oath?
Yes.
El Paso Electric Company offers EPE exhibit number 6 along with accompanying exhibits.
Thank you, Ms. Harris. Any objections to the admission of the corrected, as discussed here today, the corrected version of EPE Exhibit 6 into the record? Seeing none, it's so admitted.
Thank you. And at this time, we tender Mr. Hernandez for cross-examination.
Thank you, Ms. Harris. Okay, Mr. DeSalen, any questions for Mr. Hernandez?
No questions, thank you.
Thank you. Okay, not seeing Mr. Herman. So, Mr. Simpson, any questions for Mr. Hernandez?
No, sir, Your Honor. Thank you.
Thank you. Ms. Lynch, on behalf of Prosperity Works, any questions? Okay, I'm assuming that the answer is no. And then Mr. Friedman, any questions on behalf of staff?
Yes, staff has a series of questions for Mr. Hernandez.
Okay, please go right ahead.
Good morning, Mr. Hernandez. Glad you're here. Hope
Thank
you're
you. Good
doing
morning.
well. If I can just start you off with going to your direct testimony.
Okay.
Specifically page 4, lines 1 through 3.
Page 4, and then you said the lines?
Lines 1 through 3. It's right there at the
Oh.
top of the page.
Yes, I'm there.
And I'll read it off if that's okay with you. And you wrote staff's recommended baseline incentive increase would cause EPE to forgo a fiscal.
I'm sorry, did you say my direct testimony?
I'm sorry?
Did you say that page 4 on my direct testimony?
Oh, your rebuttal testimony.
Oh,
I apologize.
Apologies, okay.
If I was not clear, I'm not sure.
Okay, so page 4, lines 1 to 3 on my rebuttal. I'm there.
Yes. See it?
Yes, sir.
Okay. So there you wrote staff's recommended baseline incentive increase would cause EPE to forgo a fiscal year 2025 incentive even if EPE exceeds its fiscal year 2025 annual savings targets already recognized by the commission. Do you agree that I quoted your words correctly?
Yes.
Mr. Hernandez, were you a witness in EPE's previous energy efficiency case plan for the years 2022 through 2024, known as case number 21-00114-UT?
Yes.
And to your knowledge, in that case, did EPE explicitly request and did the commission grant or approve authority for EPE to use an annual savings target rather than the statutory requirement savings of 5% of 2020 sales by 2025?
Are we talking about the baseline incentive mechanism that was approved in that case, or just the savings goal for 2025?
I believe it was the savings goal for 2025.
Oh, I'm not too familiar with that, but I think can you repeat the question?
Sure. So in case number 21-00114, did EPE request the commit and did the commission grant authority for EPE to use an annual savings target rather than the statutory requirement of a annual savings of 5% of 2020 sales by the year 2025? And that statute's coming from 62-17-5, just for your reference.
I know that we established a new baseline incentive. We moved it from 12 gigawatt hours to 16 gigawatt hours in order to calculate the minimum savings needed each year to be able to calculate or to earn a utility incentive. But I don't know about the savings. I was only really involved with the utility incentive calculation.
Okay, we can move on. If you can pull up staff's exhibit 5. And since you were a witness for EP in case number 21-00114-UT, so staff's exhibit 5 is and I don't know if I'll pronounce the name right because I was not part of the case, Araceli Perea's testimony in that case. And if you can look at page 10 of that testimony and read lines 2 through 8 for me.
I'm sorry, what was the page number again? Like page 10, right?
Page 10, yes.
I'm sorry, I just found the exhibit.
Lines 2 through 8.
Page 10. Lines 2 through 8. Okay.
Do you need a moment to read through that?
Sure, I'll read it. I'll read it over. Okay.
Based on what you just read, is it fair to say that EP has known about the statutory savings requirement since at least the company's previous filing?
Yeah, I would say so.
And is it fair to say, in determining what you've described in your rebuttal testimony as an annual savings target, that EPE simply took the 2025 required savings of 78,872,865 kilowatt hours and divided that by 5?
No, I mean, that's how it was done, but that wasn't something that EPE did. That was something that was, I believe, recommended by other parties in the case. and EPE agreed to that. As again, I just want to make sure we're being clear. Are we talking about what I testified to, which is the utility incentive, or like the annual goal, or I'm sorry, the total goal that I'm still not sure which one we're talking about, because I only really testified to the utility incentive calculation that we calculate annually.
The utility incentive is tied to the savings, right? So the utility incentive would be, to be more clear.
Okay, thank you. Yes. So yes, it was
And
established in the last proceeding that it was 16 gigawatt hours. That's what we agreed to.
and just for clarification, that so by dividing it by 5, is that 5 years? Is that basically the 5 years during the relevant time period of 21 through 2025? Is that how that works?
Honestly, I don't even know that. I just know, but I believe so. I believe so. I just don't want to tell you incorrectly, because I think we ended up agreeing to 16, which wasn't exactly what it calculated to be. But yes, I think essentially yes.
Okay, we can move on. Thank you for that. If you can now direct your attention to Staff Exhibit 4, and that's EPE's application in 21-00114. And if you can look at page 8 of that application.
Staff Exhibit 4, okay. And
And
I'm sorry, the
page
page
8.
number?
Page 8. And near the bottom of page 8, you'll see the word in bold, wherefore. Do you see that? And that's where it lists requests of the commission, and it carries on into page 9 for the case.
Yes, I'm there now.
Okay, so you'll see a total of 6 requests there written down. One of which is a request for approval of a utility incentive. Can you just look over those 6 requests and let me know when you've read them?
Did you mean, I'm sorry, letter A or letter B?
Oh, okay, so let me clarify. So you see where it says wherefore? And
Yes.
then it's going to list numbers 1 through 6 of
Oh,
EPE's requests for the commission regarding the application, right?
Yes.
So based on what did you read the 6 requests?
Sorry, I just read the first number 1. Let me read the ones in the next page. Or did you
Okay.
need me to read the ones in the next page, or?
Yeah, I want you to be familiar with my question on it. So
Okay.
If you can read them.
Sure. Okay.
So do any of those 6 requests from EP's previous energy efficiency application mention or describe or request an annual savings target for approval by the commission?
No.
Okay. As a witness to this case, have you reviewed or are you familiar with the Efficient Use of Energy Act and commission rules?
Not honestly, not as much. Since I'm the rates witness, I just calculate the tariff based on what we have established. I mean, I think like I couldn't quote you anything, or I don't know the exact things, but I mean, I do try to be compliant with what we've established, from case to case.
Well, then are you at least generally aware of the EUA and commission rules pertaining to these cases, these
I'm
types of
gonna-
cases?
Object.
Okay, what's the
Uh,
basis for your objection?
Mr. Hernandez does not testify about the act and the rule directly.
Okay. Mr. Friedman, any response?
His testimony, APE's testimony, his testimony has to rely on rules, statutes, commission rules. I would imagine he would have some familiarity, and I think it's necessary to establish whether he has familiarity with those rules when drafting his testimony.
Okay. Well, I'll overrule that objection, but I do think that he can only testify to what he knows, and he can't be asked for a legal conclusion. So I assume that you'll take that under advisement as you frame your questions.
I understand.
I'm sorry, was there a question? I don't know if you were expecting me to answer something.
Mr. Friedman?
Oh, yeah. Are you aware of the Efficient Use of Energy Act and just the commission rules pertaining to these energy cases?
I would say I'm vaguely aware. I couldn't tell you any details sitting here right now. I to be honest.
Okay. So now if we can just switch gears to Staff Exhibit 8, if you can pull that up. That is the Efficient Use of Energy Act. And if you can just take a moment to read through 6217 5G. You don't have to read it out loud, just let me know when you're ready.
Okay, give me the page. I'm sorry.
So it's gonna be on the first page because it's
Okay.
no, it's a second page, sorry.
Oh, okay. I'm sorry. And then you said
Subcategory G.
okay, thank you. Okay, I've read G.
In that text, did you identify any reference to an annual savings target?
I'm going to object again. Mr. Hernandez testifies to the incentive mechanism, but not about the cumulative savings target.
Mr. Friedman, how do you respond to that?
It's my knowledge that the incentive mechanism is tied to saving goals. And that.
Okay. I mean, I think you can ask Mr. Hernandez about the basis of his testimony, but it feels like we're straying a fair bit beyond the scope of what he testified to. Can you narrow your question down or direct him a little bit more specifically to what he's testified to or what the basis for his direct testimony was?
I think I can actually, based on questions I previously asked, I think I can actually just skip this question, hearing examiner Kringkamp.
Okay.
And I can probably just move on.
Okay, let's do that.
If I can just have a moment to readjust where I'm at. Okay, Mr. Hernandez, if you can turn to your rebuttal testimony again. Page 3, line 14 through 18.
The page number again, I'm sorry.
Page 3 of your rebuttal.
And the line?
Lines 14 through 18.
Thank you.
And I'll read it off. And you wrote, it was reasonable to get the baseline level for annual savings at 16 gigawatt hours in EPE's previous EE/LM filing because it was established in that case that EPE had an average annual savings of 15.77 gigawatt hours to reach its 2025 savings goal. From that perspective, staff's proposal to move the baseline to 19 gigawatt hours so close to 2025 is akin to moving the goalposts on EPE. Did I quote what you wrote correctly?
Yes.
Just one moment, please. Can you explain this?
I think it would really help if I show you in my exhibit. It's actually in my direct testimony, but I think it might help illustrate. So if I were to show you, exhibit. So we go to my direct testimony, and it's going to be exhibit. Sorry about that. Exhibit AH3, and it's page 1. I think this might help explain kind of the approach I take with this. Let me know if you're on that page. I don't want to start until you guys are ready.
You said page 3.
Exhibit AH3, and it's page 1.
Oh, page 1.
Mr. Hernandez, just to make sure I'm following you, we're on your direct testimony, exhibit AH3, page 1 of 1.
Yes, sir.
Got it. Thank you.
All right, I'm there.
Okay, Mr. Friedman. I think it would help to explain it this way so that we can see that I kind of take this year by year. So since the last proceeding, we had approved, or it was approved that the minimum baseline incentive, in other words, for us to meet a utility incentive, we would have to exceed 16 gigawatt hours. And if we look on column C of this exhibit, you can see that, for example, in 2021, we earned it because we exceeded the minimum. But in 2022, we didn't exceed it, right? So we didn't include so the way that I just want to explain that the way that I do the calculation and the utility incentive calculation is done for each plan year. And so in order for me to measure how we performed each year, I do need to take some annual savings number. And so what was agreed upon in the last case was the 16 gigawatt hours. And so each year, that's what I go and I compare to, and we either earn it or we don't. And so, for example, in 2022, we did not earn it, but in 2021.
Am I having audio problems or?
I'm sorry? Can you hear me? I'm sorry.
If you can repeat a few sentences back. I don't know if it just happened on my computer, everyone else's, but the audio dropped.
I'm sorry about that. I'll slow down as well. I was just making the point that each year we evaluate in order to see if we earn an incentive, we have to look at the savings each year. And so for me to determine if we have earned an incentive, we'd have to see that if we'd have to have an annual number to compare to. And so what was established in the last proceeding was that it would be 16 gigawatt hours. And so if we and that's the floor. If we exceed that, then we meet the minimum required, and then we can include the incentive like we have in 2021 here on this table here, and in 2023. And if we don't reach 16 gigawatt hours, then, for example, like in 2022, we do not we don't earn it, and so we don't include it in our plan year costs for that year. But I think what I wanted is make the overall point is to say that I need an annual number that we established in the last case, which was that 16 gigawatt hours. I understand that it could be based on this long-term goal, but annually I need something to compare it to. And so we use the 16 gigawatt hours.
So referring to your exhibit AH3, you said EP received an incentive in 2021 when EP earned the incentive because EP met a savings goal, right?
Yes, sir. The established 16 gigawatt hours per year in order to get the incentive.
So then EP earns the incentive by meeting a savings goal. That's how the incentives are.
Yes. I think
So that's how it's. Go ahead.
I'm sorry, I don't mean to jump in. I just want to make sure that I worded correctly because it's the baseline savings. I mean, it is a goal. It's an annual goal in order to get the incentive, but it's the baseline savings level that we have to meet each year. But we can say goal if you want to use goal.
So then is that how incentives are tied to the savings goals? Is that
on an annual basis? Yes, sir.
okay? So then based on your rebuttal testimony that I just read,
yes.
Would you agree that based on the EUEA, that EP must achieve a 5% energy savings based on EPE's 2020 retail kilowatt hour sales by 2025?
All I can say is that we had established that it was 16 gigawatt hours per year. I understand there's some years that we don't meet it, which might cause us maybe not to meet the overall goal. But I couldn't tell you about the EUEA rule. Sorry about that.
If you can go back to your rebuttal testimony, I actually have to flip there too.
Okay.
And if you can refer to page 4, lines 1 through 3.
Page 4. Okay. Yes, I am there.
Okay, and there you wrote, staff's recommended baseline incentive increase would cause EPE to forgo a fiscal year 2025 incentive, even if EP exceeds its fiscal year 2025 annual savings targets already recognized by the commission.
It's plan year 2025.
Oh, plan year. Okay, thank you for the correction. Do you see that? Did I read that correctly?
Yes.
Okay.
Was there a question? I'm sorry, I might have missed it.
No. I'm gathering my thoughts. Okay. Sorry for the long pause.
No, it's okay.
Can you explain why EPE didn't file for a variance if it noticed that it would be difficult to meet the EUEA goals for 2025?
I'm sorry, I can't.
And can you provide a reference regarding the annual savings target that you've referenced by the commission?
All I can point you to is the established 16 kilowatt hours that we agreed to in the last proceeding as that annual target that we should meet in order to meet the baseline to get the incentive.
Okay.
But I guess technically that was approved by the commission, right? That mechanism,
What mechanism are you referring to?
the baseline incentive mechanism that we established in the last proceeding.
Well, so give me one moment. I want to make sure I'm clear. So are you stating then the commission established an annual savings target in 21-00114?
No, I'm just saying that we established a baseline level to see what we would need to meet on an annual basis to be able to calculate either if we earned an incentive or if we did not earn an incentive based on verified savings each year.
So then you have no reference for the recognition occurred by the commission for annual savings targets, right?
I don't, yeah, no, I don't think so. I think it's just based on what others recommended in the last proceeding, which I believe they might have used that goal as a way to come up with a basis for an annual average, maybe. And then we agreed to that. And so that became the new baseline level that we started using to measure our plan year savings on and to calculate whether or not we meet the minimum required to either earn an incentive or not to earn an incentive.
And for the
Thank
record,
you
that
for
was
that.
the commission's order.
I'm sorry, I'm very confused. Ms. Harris, did you have an objection or a clarification for the record?
A clarification that the 16 gigawatt minimum to achieve the incentive was part of the recommended decision in the last case.
Okay. Thank you.
I'm ready to move
Supported by
on.
the commission.
I'm ready to move on as well, so that would be helpful.
And I'm almost done here, hearing Sam Camp.
Okay.
I just have a few more. But Mr. Hernandez, if you can refer back to the staff's Exhibit 8, and that is the Efficient Use of Energy Act. And I understand that you don't have a lot of specific knowledge regarding it based on what you previously said, but if you can just look at 6217.5H for me, and
6217.5
H,
H. Okay. Let me
and
take
that's
a look at
on
it.
page, so that'll be page 2 of staff's Exhibit 8.
Thank you.
And if you could just take a moment and read it for me, read it to yourself, it's fine.
Okay. I've read it.
So 62.17.5H articulates that a utility shall propose alternative requirements if the utility determines it cannot achieve the minimum requirements established in the statute. To the best of your knowledge, has EPE made such a proposal to the commission?
I'm not aware. So just to explain my role, like I usually come in after the fact, like after the year is done, and I then get the verified savings number, and then I see if we met the baseline or not in calculating what the tariff would be, or in calculating the reconciliation of any over or under collection of the tariff. I wouldn't know about the savings like prior to the end of the year, and if they're going to meet their goals or not. I don't have much knowledge on that, sir. I apologize.
No, that's okay. Thank you for your clarification. I have no more questions hearing Examiner Greenham.
Okay, thank you. Hearing Examiner Ryan, I have one question that I can ask. Do you have any questions you want to go first?
Mr. Hernandez, I wanted to confirm the cumulative bill impacts of this and the previous energy efficiency applications.
Okay.
If I look at the application itself in this case, it's just the first pages of the filing. If you have it in an electronic format, it's going to be PDF 13 of 259. It's paragraph 18. And what it basically says is that the bill impacts will be an increase of 39 cents over the current EU ERF charge, or a 6% increase relative to the current bill. And if I understand from the last case, 21-00114, the bill impact was 1.5%, and I'm reading that from the recommended decision. So I just want to confirm that it's a 2.1% increase, if that is in fact what's occurring.
And I can answer. Oh, I'm sorry, sir. Did you have more?
No, I'm just trying to, the basic question trying to ask is, what is the cumulative impact of the two past energy efficient? I mean, the previous one plus this one now.
I think I have an answer for you, but I don't remember the exact percentage that the rate used to be back in the 2021 proceeding, but I believe it was close to 3%. And in that case, it went from about 3% to well over 4%. What finally ended up getting approved.
Okay.
And in this case, I think we're going from like our current EU ERF is like 3.4%. I have it somewhere here actually. And we're proposing 3.7% around there. So it did move up just slightly compared to our last proceeding.
So if I understand correctly, you just roughly like almost 7% increase in the two cases?
I didn't do that calculation. I apologize, but I do think I can confirm that it was a much larger increase in the last proceeding.
Okay.
Because it went from like about 3% to like 4 point something, where in this case I think it's going from like 3.4 to about 3 point, with the correction 3.7%.
3.7 independent of the previous increase. Or cumulatively.
Yes, and I'm only talking about how the tariff changed.
Yeah.
The current tariff is 3.4, and then it's going to change to 3.7%. So that's a small, I calculate in the exhibit, which is going to change because of that slight correction we have to carrying charges. But it was about, in my rebuttal testimony, the exhibit for bill impact was about, it was like under 1. It was like was it like 0.4%? I just want to confirm that. For a residential customer, with average use of about 700 kilowatt hours per month, it would be 0.4% increase.
Okay. That was your rebuttal testimony.
Yes, sir, just because I had a more updated number, which included carrying charges as well, even though, yes, I do have to correct for that small change in the rate, the treasury rate. So we'll be providing those. As soon as I have them, I will make sure we provide those to all of you.
And I'm just, can you direct me to where in your rebuttal I could find that percentage information?
Yes, sir. It's gonna be in my exhibit AH2R.
What PDF page is it?
Oh, let me take a look.
Of 31, unless you're working on paper.
I'm on paper now, but I can see if I can.
Well, no, it's fine. AH2.
AH2R.
Mm-hmm.
And I think the one that would matter more, but I think a lot the percentage change is going to be similar. But the very page 1 of that exhibit, you would see the residential numbers.
Page 1 of 16.
Yes, sir. I think it might be 15, but yes.
Sorry, 15. It's such a small number. I see there, total bill. Was this similar document supplied in the 21 case?
The 2021 case had a more summarized amount. It would take it would show you the total bill column, and then it would show you the previous EUERF charge, and then the proposed charge, and then it would take the difference between the two, because everything else stayed the same, so it was just more summarized. This one's a little better because it gives you all the billing detail in all the columns, and then it also has the different usage. So I think this was just a lot more transparent, and I thought a little more clear. So we changed the exhibit.
Okay, thank you. That's the only question I had.
Thank you. I guess it's good afternoon, Mr. Hernandez. Thank you for your testimony today. I just wanted to ask you, you testified a little bit about this exhibit in your direct testimony, exhibit AH3. If you remember that line of questioning from Mr. Friedman.
Oh, yes.
Yeah, and my question to you, because you emphasized, your role in this proceeding, and that I think is well taken. My question to you is about the calculation of that column C, the utility incentive. Can you just tell me a little bit from your perspective or from your role in this, what goes into that calculation? How do you get to that calculation of the utility incentive?
Well, I can direct you to page 4 of exhibit AH4, where I show the incentive calculation. And there's where we show what the incentive we would calculate would be if we were to meet the 16 gigawatt hours or go above that. But it would pretty much be just to kind of talk about the process, how it would work. I would get the annual savings number, the verified savings number. And once we knew what that is on a gigawatt hour basis, I would then go back and compare to what was approved for our incentive mechanism calculation. And so the first thing I would look at is, okay, did those savings exceed the 16 gigawatt hours or not? And if they do, then depending how much we exceed by, we could move up by, I believe, for each gigawatt hour over, it's 0.075% that we can get a little more, because the baseline level is at 6.6%, but it goes all the way up to our approved weighted average cost of capital, which is 7.18%. So it can't exceed that. It'll just go between that range.
Okay, and how do you then make that calculation on a monthly basis? Because in this AH3, it appears to be done on a monthly basis, right? Where I see January 2021, there's a utility incentive, and it sort of goes up and down on the months. Do you see what I'm getting at? I'm just curious, how do you make that calculation on a monthly basis?
I think it's just a percentage based on the expenditures. Or it's kind of like proportional to the expenditures.
Okay.
Um,
Okay. So does that mean, are you talking about column A there? It's proportional to column A? Okay.
Yes.
Okay. Okay, that's helpful. I think that's all the questions that I had. Let's see, Ms. Harris, any questions on redirect?
Yes, just one or two questions.
Okay, go ahead.
Mr. Hernandez, do you know if the 16 gigawatts ordered as the baseline for the utility incentive mechanism in the last EELM case was ordered by the commission?
As far as I'm aware, it was in the recommended decision, and then it was approved. The final order approved the recommended decision. Is that, I don't know if that would mean the same thing as the commission ordered it, but if it does, then yes.
Okay, thank you. I don't have any further questions.
Okay, thank you. Let's see, any questions from any of the interveners? Okay, seeing no questions from any of the interveners. Mr. Friedman, do you have any questions on recross?
No questions on recross. Thank you.
Okay, thank you. Okay, so let's see, anything further from EPE at this point? Any further? I don't believe you have any further exhibits or witnesses, but
That's correct. I believe this concludes our presentation of the case.
okay, thank you. All right, well, hearing examiner Ryan, it's 12:10. I would probably suggest that it's time for us to take a lunch break. I don't believe that we could get through the next witness probably fast enough. So if we wanted to take a 1 hour lunch break and come back at 1:15, would that work with everyone? Okay, so then we'll come back at 1:15, and I believe the first witness, if I'm not mistaken, I believe it'll be on to you, Mr. DeSalen, or Ms. Lynch, depending on who's available. I know you said someone might be gone between 1 and 3, and your witness, I believe, would be up next.
That's correct, Mr. Hearing Examiner. Ramon El Torre will be our first and only witness.
Okay. Okay, that sounds good. Well, we will be off the record until 1:15. Thank you.
Thank you.
Okay, I believe we have everyone back. Just before we go on the record, Ms. Lynch, I take it that Mr. DeSalen is out as we discussed earlier, and you will be representing CCAE. Is that correct?
Correct.
Okay, that sounds good. And lastly, again, before we go on the record, I did receive Mr. Simpson's email just now, as I'm assuming the rest of the service list did. We'll handle those exhibits as we discussed at the beginning of the hearing, Mr. Simpson. If you bring them up on cross, then we'll sort of take them one at a time.
Okay, thank you.
Sure. Okay. So with that, we'll go ahead and go back on the record. The time is now 1:16 p.m. I hope everyone had a good lunch break. I believe where we left off, EPE had just finished its witnesses, and it was time for CCAE to call its first and I believe only witness.
Thank you, Ramon. Oh, there you are. Good afternoon, Ramon.
If the court reporter could please swear in the witness.
Mr. Alatorre, would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And could you maybe turn your volume up just a hair?
Is this any better?
Please go ahead, Ms. Lynch.
Okay. Good afternoon, Mr. Alatorre. Could you please state your name and spell it for the court reporter?
Yes, my name is Ramon Alatorre. That's spelled R-A-M-O-N. The last name is A-L-A-T-O-R-R-E.
Thank you. And where are you employed?
I am employed with the Southwest Energy Efficiency Project, also known as SWEEP.
What is your business address?
2334 Broadway Street A in Boulder, Colorado. That is 80304 for the zip code.
Thank you. I'm going to refer you to a document that is marked CCAE Exhibit 1. Do you have that?
I do.
Okay. And can you identify it?
It is the direct testimony that I prepared for this filing.
And that would be the corrected direct testimony, correct?
It is, yes.
And when was it filed?
Originally October 11th, corrections filed on October 24th of 2024.
Thank you. Did you prepare this document?
I did.
Are there any other changes you would make to it now?
Only the corrections filed on October 24th.
Thank you. And do you adopt it as your sworn testimony today?
I do.
If you were asked any questions or the same questions that are proposed or that are posed in it, would they be the same today as they were when you wrote it?
They would.
Okay. I'd also like to refer you to a document that is marked CCAE Exhibit 2. Do you have that before you?
I do.
And can you identify it for us, please?
The rebuttal testimony of Ramon Alatorre,
And when was that filed?
November 1st, 2024.
Did you prepare it?
I did.
Are there any changes you would make to it?
There are not.
Do you adopt it as your sworn testimony today?
I do.
Thank you. Your Honor, I move for admission of CCAE Exhibits 1 and 2.
Okay, thank you, Ms. Lynch. Are there any objections to the admission of what's been marked for identification purposes as CCAE Exhibits 1 or 2? Seeing none, CCAE Exhibit 1 and CCAE Exhibit 2 are admitted into the record.
Thank you. And would you like me to admit Mr. Alatorre's resume and or the comment letter? Also known as attachments RA1 and RA2.
Are they attachments to the direct testimony?
Correct.
Well, I think consistent with what we have, so I don't actually see these. Are they in the document, the PDF document?
Mr. Alatorre, are they part of your document?
I know they were submit with direct testimony. I'm not seeing them in the Dropbox.
So in that case, they were not submitted with the Dropbox version, but they were originally submitted with the direct testimony as we've identified.
All right, hang on and let me just check that. Okay, I do show that that was in the original filing in eDocket. I think what we would need is for you to submit an updated version of CCAE Exhibit 1. Is there any objection from any of the parties, including but not limited to EPE, to admitting those attachments through sort of a corrected version of CCAE Exhibit 1? Okay, seeing none. So then, Ms. Lynch, yeah, those should be in that exhibit. And what we'll do is we'll admit those. If you could upload a corrected version to Dropbox, then that will become CCAE Exhibit 1.
Thank you, and apologies that
Yeah,
it wasn't originally included.
No problem.
Thank you.
Okay, thank you. And does that conclude your direct?
That does, and we pass the expert.
Okay, thank you. Let's see. So this brings us to EPE. Ms. Harris, do you have any questions for Mr. Alatorre?
I do.
Okay, please go ahead.
Thank you. Good afternoon, Mr. Alatorre.
Good
I'd
afternoon.
like to begin by directing you to CCAE Exhibit 1, your direct testimony, corrected, and specifically page 32, where you begin your summary. Do you agree with me that you made a number of recommendations starting on page 32 and ending on page 34 of your direct testimony?
I do.
Okay. And did you perform any sort of funding analysis based on these recommendations?
I did not.
Okay, thank you. So there are a number of issues that EPE identified in its statement of issues and agreed upon facts that we filed in this case, and I'm going to walk through several of them. I'd like to begin with the proposed inclusion of the baseline incentive rate element. This is the element of the rate that could be collected either over the course of the year or retroactively. Do you understand from Adrian Hernandez's rebuttal testimony that he agreed with staff's proposal to collect this element of the rate retroactively?
Upon rebuttal, yes, I understood it that way.
Okay, thank you. However, in your rebuttal testimony, which I acknowledge was filed simultaneously, you supported EPE collecting that element of the rate over the course of the year. Is that correct?
That is correct.
So given that staff and El Paso Electric agree on the retroactive collection of this portion of the rate element, do you consider this issue to be uncontested at this point?
I do. I think we would have supported collecting it throughout the program year, but it's not something that we're feel strongly about.
Great, thank you. Next, I'd like to discuss the baseline incentive, energy savings and utility incentive mechanism. So CCAE is recommending a 2025 energy savings target of 18.9 gigawatt hours. Is that correct?
That is correct.
However, you support continuation of the 16 gigawatt hour baseline for EPE's utility incentive mechanism. Is that correct?
That is also correct.
Thank you. Next, I'd like to turn to CCAE's recommendation to increase the number of homes targeted per year in its all-electric performance path. My question is, do you understand that their EPE's target of 5 homes is merely a target?
I believe so. Yeah, we saw 5 homes in I believe it was in the testimony of Newman. And we had taken note that the targets for the sort of mixed fuel homes was something like 60 homes per pathway. And so we thought that the balance was off.
Do you understand that EPE can strive to exceed that goal of 5 homes?
I do.
Do you agree that therefore this issue is resolved?
I think we would like to see a target higher than 5, even if it can be exceeded. Perhaps I don't know that it would be thought of as a minimum, but we saw 5 and thought that a greater target could be put forward.
Okay. Next, I'd like to turn to the low income program budget, specifically the Energy Saver budget. Do you understand that EPE has agreed to increase the budgets for its 2 low income programs for the years 2025 and 2026?
I do.
And do you understand that increasing the 2027 budget for the Energy Saver program would put EPE above the 5% of eligible revenues provision of the rule budget limit?
I do. I think that is based on projections and forecasts anticipating 2023 income being what is actually the eligible revenues to compare against in 2027. So I don't know if when we get to 2027 and are looking at actuals, whether or not it would still be above the 5%. But I do appreciate EPE sort of coming up on the low income programs for 25 and 26 as we requested.
Okay. Do you believe that it would be acceptable for EPE to violate that 5% cap that's in the rule for 2027?
My understanding is the EUEA says not more than 5.
Okay, thank you. Next, I'd like to turn to CCAE's recommendation that EPE decrease the quantity and incentive levels for cooling only HVAC equipment, and also increase the quantity and incentive levels for heat pump HVAC equipment in its residential comprehensive program, and also the Energy Star New Homes program. You recommended that the commission direct EPE to decrease incentives for cooling only and increase incentives for heat pump HVAC equipment in those programs. Is that correct?
That is correct.
Do you understand that in rebuttal, EPE agreed to increase the incentive levels for heat pumps?
I took note of that in the rebuttal submitted by EPE. Did not see much specificity in terms of what that might look like in terms of numbers, though.
Okay. And do you understand that EPE does not agree with decreasing the quantity and incentive levels for cooling only HVAC equipment?
I understand that that is what EPE has said.
Okay. And is it your understanding that EPE's reason for this disagreement is that it needs to maintain a diverse and balanced portfolio that different types of customers can take advantage of?
I read that in the rebuttal testimony, yes.
Thank you. Do you agree that EPE needs to maintain a balanced portfolio of programs?
I do. I think we were pointing out, however, that heat pumps being the sort of flexible year-round equipment that can provide cooling, that those who are seeking cooling equipment would be able to do so with a heat pump, and also benefit throughout the season. When you look at the sort of benefits received by the company, there's a clear ratio in terms of the heat pump performing sometimes 3 or 4 times the amount of energy savings per year. And so we were recommending trying to incentivize more of these heat pumps that have more year-round benefit, and perhaps having the incentives at least sort of based on some of those benefit ratios.
And based on that, I think you used the word recommendation, but do you believe that the commission should actually order EPE to do that?
We would like to see that.
Okay. Next, I'd like to turn to CCAE's recommendation that EPE eliminate the 5% above code performance path and divert those resources to the all-electric performance path. Do you understand that EPE agrees to increase resources for expanding new homes under its all-electric home path?
Again, I saw that in rebuttal, but without much specificity.
Okay. And is it your understanding that EPE does not agree with eliminating the 5% above code performance path entirely?
That is consistent with what I read in rebuttal.
And is it your understanding that EPE's disagreement with eliminating the 5% above code performance path is due to its need to maintain a diverse portfolio?
I do understand that that was what was stated in rebuttal.
Does that resolve this issue for you?
I think we would still like to see perhaps some specificity around how much more resources would be put towards the all-electric path. We were putting forward one pathway. There's still the 15% and 20% over. I think part of our recommendation was to signal that a little bit over is been sort of the way of the path, and going forward, considering the targets that New Mexico has and the Energy Transition Act and otherwise, that incentives would be for sort of higher overperformance or for going into an all-electric pathway.
Thank you. Next, I'd like to discuss the home energy report program that CCAE recommended. Did you read Victor Silva's rebuttal testimony, which spoke about EPE's Smart Energy Tools app?
I did.
Would you agree that EPE's Smart Energy Tools app includes a similar functionality to the home energy report?
Similar functionality, but I think the app would require customers to go seek it, whereas the energy reports are something that could be delivered and scanned.
Okay, so then you would maintain that EPE should be ordered to start a home energy report program?
We've seen benefits for these types of report programs, and it seems like there's the infrastructure available to be able to spin up a report like that. So I would say we still encourage it.
Okay. Next, I turn to CCAE's recommendation that El Paso Electric develop a new construction multifamily all-electric pilot program. My question is, do you understand that EPE's implementers do not offer multifamily all-electric programs in their New Mexico service territory?
I did read that in the rebuttal, yes.
Do you understand that there is little new multifamily construction in EPE's New Mexico service territory?
I also read that in rebuttal, yes.
With those understandings, do you still stand by the recommendation that EPE develop the new construction multifamily all-electric pilot program?
I think we would like to learn a little bit more about both of those sort of facts that were brought up in rebuttal. But at this time, I don't think we're going to push for that recommendation.
Okay. Next, I'd like to turn to CCAE's recommendation that EPE include information about the new state website, the ECAM, or Energy Conservation and Management, and how people can staff utility and state and federal incentive. In rebuttal, is it your understanding that EPE agreed to do this through electronic outreach, through electronic bills, as well as paper bills?
That was my understanding, yes.
And is that acceptable to you?
That satisfies.
Okay, so you consider that issue to be resolved?
I do.
Thank you. Next, I turn to CCAE's recommendation that the commission direct EPE to account for the benefits of avoided emissions of greenhouse gases and other harmful pollution. In rebuttal, EPE supported including this, but said that it will defer to this rule and the statewide evaluator. Does that match your understanding?
That matches my understanding.
And does that resolve the issue for you?
I think we would still like to see the avoided emissions benefit that was proposed by EPE be, I guess, adopted or sort of moved forward with.
Okay. I'm almost done. CCAE also recommended that EPE modify its avoided energy cost methodology to capture the time value of energy savings. Is that correct?
That is correct.
And do you understand that in rebuttal, EPE agreed to work with Frontier Energy to try to develop that?
That is consistent with my understanding.
Does that resolve the issue for you?
It does. I think we would like to just have more clarity on sort of the timeline as to when that would be brought forward.
Okay. CCAE recommended that the commission direct EPE to study using hourly avoided energy cost modeling and greenhouse gas emissions for inclusion in its next EELM plan filing. In rebuttal, is it your understanding that EPE agreed to study this recommendation?
It is.
And therefore, do you consider this issue to be resolved?
If it is brought forward in the next filing, yes.
Okay. And my last question is, CCAE recommended that EPE study whether increasing the $25 enrollment incentive would result in greater customer participation in the residential load management program while maintaining cost effectiveness. Is it your understanding that in rebuttal, EPE agreed to work with Frontier Energy to study this?
It is.
And therefore, is that issue resolved for you?
It is.
Thank you very much. I don't have any further questions.
Thank you, Ms. Harris. I appreciate it. Let's see. I believe that based on who's on the call, that takes us to Mr. Simpson.
Hey, Mr. Hearing Examiner Krankamp, I'm
yes.
sort of chomping at the bit here to
Yes.
ask some questions, and I just want to.
By all means.
And I was trying my hardest not to interject when the EPUs, and not because I had any objection to the questions, but just wanted further explanations of some stuff. Mr. Alatorre, did I pronounce that correctly?
You did.
Can you explain to me, I see in the testimony here, this is your direct, and this is a 13. It's not important to the reader. It's not very specific to this particular. I'm just trying to ask you to explain something to me. You write the 2021 to 2025 EUEA target was set at 78.9 gigawatt hours in total. I presume that 78.9 gigawatt hours in total refers back to what Mr. Friedman from staff has been referring to fairly consistently throughout the proceeding, the statutes identification of the 2025 target shall be set based on 2020 generation. Is that the idea?
I believe so. My understanding is that a 5-year target was set for the years 2021 to 2025, and that target for EPE was in that neighborhood of 78 gigawatt hours.
Okay, and the reason I'm asking that is because statute says providing shall not be less than the savings of 5% of 2020 total retail kilowatt hour sales to New Mexico customer classes. So it just seems to me that 78.9 gigawatt hours must have some relationship to that calculation. Am I right? I'm not trying to ask gotcha question. I'm legitimately trying to figure out what's going on.
Sure, that may be true. I know that the next, for 2026 to 2030 hasn't been established yet. That may be because we're waiting on 2024 actuals or 2025 actuals to come in. I don't want to sort of like get over my skis, but my understanding is that 78 was established, 78 gigawatt hours was established for the 5-year period 21 to 25.
Okay. Now then the next part of this is to figure out the next step. And you recommend in that same page there, 13, CCA would recommend setting a 2025 target of 18.9 gigawatt hours. How did you come to that recommendation? And I'm not asking trick questions. I'm legitimately asking, how did you pick that number?
I believe 18.9 would close the gap so that EPE over that 5-year period from 21 to 25 would hit that target of 78 gigawatt hours. And we were also holding somewhat separate in our minds, though, like what is the target to meet a 5-year goal, and also what is the sort of baseline or threshold in order for the utility to be able to earn the incentive. And so that is why you will see in our testimony that we would like a target to be put forward that closes that gap, but ultimately recognizing that as EPE has put forward, that the average that would have needed to have been achieved each year was around 16 gigawatt hours. They missed in 2022 for the reasons that they've explained, and didn't get the utility incentive. And we weren't sort of in a position to say that they should then, I suppose, be not get their incentive a second time because of what happened in 2022.
Okay, so I think just based on what you said has been helpful to me. They set a target based on the 2020 numbers that they had to hit by 2025, and they broke out, here's how much we'll have to do each year to get to that number. And then at some point in time, and I think Mr. First witness of today, I'm terrible with remembering things for some reason today. Our first EPE witness is Mr. Silva, correct. He described that COVID-19 happened. There were supply chain problems that happened, and then the final order from the commission came too late, and that derailed their plans for 2022 and maybe perhaps 2021. I don't recall what he said specifically. Do you remember them saying that?
I do.
Do you credit any of that?
Certainly, when looking at utilities across the region, I believe that 2022 was a difficult year for many. And so seeing that they came short on their energy efficiency and load management goals in 2022, in some ways is not surprising. They did not receive the utility incentive, as I believe Mr. Hernandez pointed out in those tables. And in all other years, they have earned the utility incentive when the baseline was set at that 16 gigawatt hours in order to be able to achieve their annual utility incentive.
Okay, and I guess I was just a little, I myself wasn't totally clear on how COVID-19 and supply chain necessarily leads to failing to get customers to engage in energy efficiency measures. I get it if you can't get parts for a nuclear reactor or whatever. That seems, solar panels get stuck because there's been some problem in Vietnam with dumping of, all that stuff I get. but I don't really necessarily know that I understand how how COVID-19 impacts energy efficiency. I mean, can you just explain to me? I mean, if that's a real thing, can you give me the overview?
Yeah, I mean, I do think it was a real thing when we look at the performance of utilities across the region. There was a dip. Part of it could be that many energy efficiency measures require, some sort of implementation or installation within a home or within a building, and that was put on pause for a while. But I believe the utilities would
Okay.
be able to speak to the specific challenges of being able to deploy. I think you are also correct that there was something about delays, either at the commission level or otherwise, that may have also presented challenges.
Okay, and so now, if I understand it correctly, the disagreement between interveners in the utility, at least at some point, and it sounds like perhaps folks have sort of shifted positions, and I just can't keep it all straight in my head at the moment. It's not important. Your position was, well, we should require the utility to reach it, and if we agreed that there was a period that they needed this much per year to hit 2025 targets, but they had some bad years. And then you guys come forward and you say, well, now we're going to say, hey, what's appropriate is for you to hit the mark, and that requires you doing more. And the utility says, no, unfair. Is that a basic general statement of where we lie with all this?
I'm not sure that that is necessarily accurate. I think that the utility is putting forward that the baseline should remain 16 gigawatt hours and to be able to
Because
achieve
that's
a
what we
utility
agreed
incentive,
on.
but they're still interested in trying to hit that 78. That's where I was saying we were kind of holding sort of almost two terms in our mind where we would like sort of a stated target to say we're still aiming for that 78 gigawatt hours for the 5-year period. In order to do that, it would require achieving 18.9 in calendar year 2025. But for us, we were satisfied with 16 gigawatt hours as being the baseline in order for the utility incentive to be sort of unlocked.
And I'm not asking you to make a legal determination, more just a question as a technical person whose job it is to understand these things. It must be that you believe there's flexibility in the law that allows you to say that that's good enough.
I think from a technical perspective, and what's been discussed in terms of that 16 gigawatt hour floor, to unlock the utility incentive, that can be appropriate, and we try to incentivize for overachievement.
But I guess ultimately the question, one part I want to ask is, why should the commission, I mean, if there's an obligation to reach a certain point by 2025, why should the commission care about, what it is that the parties and the utilities agreeing to? I mean, our requirement is to ensure the law is met. And if that requires them hitting 18 points and whatever, why should the commission just not say, well, we're sorry, go talk to the legislature?
I'm not sure I have sort of an informed policy opinion in that way. I am a little bit more on that technical side.
That last question I had was then with respect to, there's actually two more questions. The incentive that the utility gets, and you're very much educating me, and I'm asking you questions to get the education. How does that relate to them achieving the actual annual savings, energy savings that they achieve? Like, if they hit they have to meet them to get the incentive? Is that the way this works?
I believe the way that it works is that usually, I believe during these triannual filings, it is determined what is that sort of baseline utility incentive level that must be hit. It has been set at 16 for this most recent filing. We can determine what it's going to be set at for the next one. It was set at a different level. I think there is, a certain amount of math that can be put forward, with 16 gigawatt hours, that would essentially say they have to hit what they perceive as their annual targets in order to be sort of compliant and on track and on target to hit their 5-year goal. I think if you set it well above that, then it's like, well, was the original goal, that 78.9, if we're not going to allow the utility to get an incentive until they've sort of exceeded that by a couple gigawatt hours. Or what was that goal, I suppose? But I do think that there seems to be a relationship, but I don't know that it's necessarily in statute what the baseline for the utility incentive is. But I think there's some judgment that's been applied in the past where that baseline is going to be pretty close to sort of the perceived annual that needs to be achieved in order to be able to be on target to meet their 5-year goal.
In 2025.
Mm-hmm.
Okay. And lastly, just at a conceptual level, I mean, I think I understand the basics of avoided emissions and putting a price on carbon emissions and saying, well, let's factor this into how we think about the costs of this, the utility cost test. But when I was this morning, when hearing examiner Kreinkemp was speaking with it was either Mr. Silva or Mr. Newman, I don't recall, and they were pointing to like the Smart Student program, and they note that, well, if we don't include the avoided emissions costs or however you want to think about savings, then it doesn't meet, it doesn't pay for itself. But if you do apply that, then it does. And then I sort of left myself wondering, well, how exactly does avoided emissions factor into giving children literature about energy savings?
Yeah, I believe that program's more than just an education and literature. They are also sent home with kits. If those kits are, deployed where they replace a light bulb, or perhaps they put insulating film on their windows, or I don't actually know the specifics of their kit program, but I am familiar with some of the other kit programs. A certain amount of costs were put into, supplying all of those kits. And then if they go home and they sort of end up utilizing all of those, then there would be energy savings that would be enjoyed by the homes and by the system in general. And if you actually put a price on those kilowatt hours that have been saved as a result of the students going home and participating in energy efficiency, then it sort of turns the dial up. If it was 100 kilowatt hours that were saved, and I think we heard something like 3 cents per kilowatt hour, that would be, I guess, $3 that have been saved right there. So I think that's how it works, is that they go forward and say, based on the projected energy savings, and if we apply this 3 cents per kilowatt hour to the energy savings that were happening, then it provides this adder to sort of our baseline UCT cost effectiveness test.
And I guess the reality of what I'm at, I sort of, that was a specific example, perhaps, of the broader question would be, should the commission have any concern? And by commission, I mean myself, and then the commissioners who ultimately have to make the determination that, when we talk about reduction of energy usage, we can very much say empirically, well, this caused this much of a reduction in energy, and that's sort of a hard and known thing. When you begin doing things like avoided emissions and considering the costs of them that are saved, you begin to slip from something that's, and I would fully acknowledge it's an empirical analysis, but it seems like it makes it adds in accessory matters that perhaps would be easier for the make it easier for the utility. Does that make any sense?
I think so.
The commission wouldn't want to water down the requirements by saying, well, look, you're avoiding emissions, therefore that's a great benefit, let's bring it in. Whereas
Sure.
in reality, all this is about is reducing the total amount of electricity utilized.
Right. And I think it would go towards demonstrating the full value of energy efficiency and load management, that it's being somewhat undervalued based on the tools that we have available now, especially when you take into consideration some of the policy environments that we are operating under, in order to hit 2030, 40, 50, renewable energy goals. And otherwise, I'm not entirely sure that our sort of standard cost effectiveness tests are up to the task at the moment. And so applying a lens that is putting a value on avoided emissions, reduction in energy, I think is consistent with some of the policy landscape. And we've also seen it sort of the commission apply some of that interpretation and expansiveness I mentioned in my testimony by including adders and having to have conversations around what is the discount rate and otherwise. So there's a lot of judgment, I think, that is put forward in these, and we would like the judgment to include valuing avoided emissions.
And the emissions themselves that are being avoided, is that at generation points in the electricity chain, or is this at individual levels as well?
I think it can be both. I believe that the approach that EPE put forward, they're talking about their own emissions intensity, sort of as a company broadly. So it's a pretty high level average. This is our rate per kilowatt hour, and then, but certainly, if we're talking about electrification measures in people's homes, that could also be improving indoor air quality and things like that. But I believe that the protocol put forward by the company really is more at a systems level.
Well, and I just guess partly I'm asking that question because as we move towards a more fully renewable system, 2025 will be at 40%, right? At what part? I mean, because the emissions issue ostensibly would be disappearing as we get into like a fully renewable system.
That's correct. Yeah, I suppose incremental value as it gets cleaner, the maths would certainly be updated on an annual basis.
Okay, those are my questions for now. Thank you.
Thank you. Mr. Simpson, do you have any questions for Mr. Alatorre?
No, I don't. Thank you.
Okay, thank you. Let's see, that brings us to, I believe, Mr. Friedman. Mr. Friedman, do you have any questions for Mr. Alatorre?
No questions.
Okay, thank you. I guess that brings us to me. Mr. Alatorre, good afternoon to you. I just have a couple of questions following up on some of what you've been asked about from Ms. Harris and then Hearing Examiner Ryan. Since we're on the subject of the avoided cost, this emissions item, let me ask you about the utility cost test. Can you tell me how the avoided emissions benefit, how exactly that, at least on a conceptual level or from a policy standpoint, from your perspective, how that fits into the utility cost test?
Yeah, my understanding of the utility cost test, you're evaluating the costs for the utility to, I suppose, provide and implement energy efficiency and load management programs, and comparing that to in some ways, the avoided costs, but the benefits as a result of not having to, or comparing it against supply side resources. And potentially also things involved with regulatory compliance and such. So if there was a fee for a certain amount of energy, that could also be sort of incorporated in. And then, in our opinion, by incorporating the avoided emissions benefit, you are recognizing what has so far been sort of an externalized benefit of avoided emissions, and that there is a robust methodology out there to be able to put a dollar value on that. And that when you consider sort of the policy environment, that the utility cost test, I think, under a number of different circumstances in the past, has been modified, or an accommodation has been made in order to make it align with policy in New Mexico, or and things like the 20% adder for low income customers is not explicitly mentioned in the EUEA of or in the definition of utility cost test. And I think that's just one example, but when looking at the utility cost test, I think there's sort of a history of recognizing that it is a somewhat rigid tool and that applying appropriate modifications to be aligned with policy would allow an analysis that is recognizing the value of energy efficiency and load management.
Okay, that's helpful. Let me ask you about page 30 of your, this is your corrected direct testimony. You were asked by Ms. Harris about EPE's recommendation, I'm sorry, CCAE's recommendation that EPE implement a home energy report program. Can you explain a little bit more behind this recommendation and how it would work in practice? Because I found it difficult to follow.
Yeah, I'd be happy to. A lot of home energy report programs, a company would put together maybe like a 1 or 2 page sort of analysis of the home to be able to compare to perhaps like last month's energy usage, last year's energy usage, or same month last year. Be able to see some trends over time and potentially also put in some recommendations about things that a customer might be able to do in order to be more energy efficient at their home. Some versions of home energy efficiency reports might also talk about similar homes in the area, like are you kind of on the high side or the low side? And it's a fair bit of information, but it is sort of like delivered in like one nice little package. By being able to see some of that, you are able to effectuate people that might be interested in recognizing, oh, like I'm 50% higher than some of my neighbors. I wonder if there's some low-hanging fruit that I might be able to sort of move forward with in order to save some money and save some energy. So that's the type of program that the home energy report is, as I believe was mentioned by EPE. They have some of those tools, but you have to go and like actively seek it out. And the research has found that when that is provided, first of all, lots more eyes compared to the number that might go seek it out on their own. And you may be able to sort of nudge more actions in terms of achieving energy efficiency and load management than if you didn't bring that forward to them and make it available. And if it's done digitally, I think that is appropriate in today's age. A lot of home energy reports historically have been like a bill insert or something like that. And I think that was part of our conversation where I think we agreed that it would be appropriate to see it in like an electronic bill or otherwise.
Okay, that's helpful. And I would ask you the same question about your recommendation for the inclusion of this new construction multifamily all-electric pilot. Can you walk me through that and what the rationale for it and how it would work?
Yeah, I think we certainly were getting more information from the company in terms of sort of how much new multifamily construction is happening. I think by and large, when we look at sort of the entire Southwest region that SWEEP represents, we're always advocating on behalf of both single family as well as multifamily products and programs and offerings. So that was certainly part of the interest, and we want to make sure that that sort of remains in the ether. And whatever multifamily construction is happening, we would like to see it move forward in a way that is going down an all-electric pathway. So whether it's in that commercial realm, whether it's in the new homes realm, I think there is certainly a piece of us that would like to have it remain in the record that when it comes to multifamily, we would like to see programs that are supporting the building of efficient and all-electric multifamily units.
Okay. And did I hear you say on cross-examination from EPE that this is no longer a recommendation, that I believe you said you're no longer actively pushing it in this particular case? Is that right?
I think in the sense that we would like to still get more information about the multifamily space. I think it would remain a recommendation for us, should multifamily construction be proposed in the EPE area, but if it's not appropriate at this time for a pilot, we would certainly like to see it revisited and to make sure that that sort of level of data continues to be brought forward in future filings.
Okay. Thank you. Hearing examiner Ryan, did you have any other questions that came to you so far? No? Okay. Ms. Lynch, any questions on redirect?
I'd just like to ask a couple of questions.
Sure, go ahead.
Okay. Mr. Alatorre, would you agree that energy efficiency results in energy savings?
I would.
And energy savings, does that mean that less energy is used?
Yes.
And less energy used means less energy generated, correct?
Correct.
Is it also true that the less energy that's generated, the less the emissions result?
I'd say that is often the case. There has
Okay.
certainly been discussion around the time value of energy as well. And we were glad to see EPE recognize and say that they would look into that. There can be an element of a kilowatt saved at noon is different than a kilowatt saved at midnight, but certainly the less energy that is generated, typically the cleaner it is.
Wait, sorry, can I just follow up on that point right there? Because I appreciate you bringing it up again. Fill in the next step in that. I mean, I've heard Commissioner Ellison talk to me at great length about how, as we move towards a renewable system that's heavily solar based, at noon you have excess capacity. So is that the idea that like the noon hour piece of energy is actually just that's not the thing we care about because we have so much at that time? Is that the idea?
Might have a different value if we were thinking about time value of energy. It would be perhaps higher value to be able to save a kilowatt at midnight than at noon, or to be able to load shift into that noon, to be able to recommend if you've got flexible loads rather than doing your laundry at midnight, perhaps do it at noon. So yeah, that's part of the idea there.
Okay. And this is discussed at greater length. So if I want to go read this to be clear in your testimony, the time value concept.
It is mentioned in the testimony. I don't know that it's extensively unpacked.
I'll figure that.
Yeah.
Go ahead, Ms. Lynch.
Hearing examiners, those are all the questions that I had. I appreciate the opportunity and the elaboration.
Okay, thank you. Let's see. Any questions from any of the interveners on recross or from staff?
I would love to ask just 2 questions if possible.
Yes, please go ahead, Ms. Harris.
Mr. Alatorre, has CCAE put forth the contents of what a home energy report program would contain?
I'm not sure if we have.
Okay, and has CCAE put forth the contents of what a new construction all-electric pilot program would look like?
For multifamily?
Yes.
No, I don't believe we have.
Okay, thank you. That's all I have.
Okay, thank you. Unless there's anything else, I believe that's all the questions that we have for you, Mr. Alatorre. Thank you so much for making yourself available today.
Thank you. Appreciate the time.
Thank you. Anything else, Ms. Lynch, from CCAE?
No, thank you, sir.
Thank you. And I believe that takes us to, you, Mr. Simpson.
Yes, I believe you're right, sir.
Okay. And I think the way that the commission's practice, I'm informed from hearing examiner Ryan, the way we'll do it, we'll get you sworn in. I will go through your questions for you as far as getting your direct testimony admitted.
Okay.
And then we'll make you available, I guess, for cross-examination. So, Ms. Hoyman, if you wouldn't mind swearing in the witness, please.
Mr. Simpson, would you raise your right hand for me, sir? You solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
Well, good afternoon, Mr. Simpson. If you could please state and spell your name for the record.
My name is Philip Simpson. It's PhilipSimpson.
Thank you. And are you a pro se intervener in this case?
Yes, I am.
Okay. Do you have before you what I believe has been marked as Simpson Exhibit 1?
Yes, I do, sir. And I'd also like to mention I have a couple of corrections whenever that's convenient to discuss.
Well, let me ask you this. We'll get to those. Let me ask you this. What is that document? What is Simpson Exhibit 1?
It is my direct testimony in this case.
Okay. And was that testimony prepared by you or at your direction?
Yes, it was.
Okay. So you just mentioned some corrections. Do you have any corrections to make? And if so, can you just outline what those corrections were?
Yes, I have corrections on 2 pages. And by the way, these corrections were included in a version, an updated version of Exhibit 1 that I sent out in my email and of an hour or 2 ago. And also I uploaded these corrections to Dropbox. The first correction is on page 11, in between lines 13 and 14. There's a table, and the third entry in the table, UCT, including avoided cost of natural gas, the value for under AC in the AC column should be 0.77, not 1.13. There's a related change on page 24 in the big table on page 24. The second line from the bottom, UCT including avoided cost of resistive heat, instead of 1 under the AC column should be 0.77, not 1.13. In addition, 2 lines above that, 4 lines from the bottom, UCT including avoided cost of natural gas, again, the 1.13 in the AC column should really be 0.77.
Okay. Is that the extent of the corrections?
That is, sir. Thank you.
Okay. And it looks like, just for my own purposes, it looks like you've marked all of your corrections, sort of highlighting them, and then a little red flag up in the corner. Is that correct?
Yes, I did. And I realized later I should have done a strike through, but I was kind of in a hurry.
No, that's fine. Okay. So, and again, just for my own purposes, have you uploaded this corrected version to Dropbox?
Yes, I have.
Okay.
Is the other version there too as well, Mr. Simpson? I mean, you don't have control over it, so the answer to that question is probably yes.
Yes, unfortunately.
So hearing the Crankamp, the important thing will be, and this is useful perhaps for the parties to be aware too, is just you make sure to go into the Dropbox afterwards and delete the wrong one so that Ms. Hoyman has only the hearing examiners have the control to do that, right? Because we have access to the Dropbox. So then Ms. Hoyman, when she pulls from Dropbox, will only be pulling Mr. Simpson's corrected exhibit.
Yes, that makes sense. And that'll extend, I guess, to, I think we had another corrected exhibit earlier, so we'll do the same thing with that.
Yeah, and it'll in particular, like in the P&M Ray case, we'll find this happens somewhat frequently, which is why we strongly discourage corrections. But I'm with like numbers like this, I can understand why Mr. Simpson had to do that. But at some point it just becomes, it's chaos. So, but then this is a small case, so not a big deal.
Okay. So let's see. So Mr. Simpson, if I asked you the same questions today that appear in your direct testimony, would you give the same answers?
Yes, I would.
Okay. And would those answers be true and correct?
Yes, they would.
Okay. And finally, are you moving what's been marked as Simpson Exhibit 1 as corrected into evidence today?
Yes, I would like to do so.
Okay. So at this point, based on my questions and what's been presented from Mr. Simpson, are there any objections to the admission into evidence of what's been marked again and corrected as Simpson Exhibit 1? Okay, seeing none, Simpson Exhibit 1 is admitted into evidence again as corrected. And then I guess lastly, Mr. Simpson, are you making yourself available for cross-examination at this time?
Yes, I am, sir.
Okay, thank you. Okay, so that concludes the direct examination such as it was. So that brings us to EPE. Ms. Harris, do you have any questions for Mr. Simpson?
Yes, just a few, thank you.
Okay, go ahead.
Good afternoon, Mr. Simpson.
Hello.
My first question is, are you familiar with the process that's used for developing and updating the Technical Resources Manual, or TRM?
Yes, I mean, I'm fairly familiar with the TRM. I'm not sure I'm totally up to speed on exactly how the TRM is developed by the evaluator.
Okay. Are you aware whether the TRM is updated by the state of New Mexico's independent evaluator?
Yes, I am.
And is the TRM updated by the independent evaluator?
That's my understanding, yes.
Okay. Is it your understanding that that evaluator is appointed by the PRC?
I was not aware of that detail, but that makes sense.
Okay. And is it your understanding that the TRM is provided for utilities to use?
Yes.
Okay, thank you. I don't have anything further.
Okay, thank you. Ms. Lynch, any questions from CCAE or I guess Prosperity Works?
Not at this time.
Okay, thank you. That brings us to Mr. Friedman. Staff, do you have any questions for Mr. Simpson?
No questions from staff. Thank you.
Okay, thank you. Hearing Examiner Ryan, any questions?
No, good to see you again, Mr. Simpson.
You too, sir. Thank you.
Mr. Simpson, good afternoon. I'll just ask you just a couple of questions. You've heard the testimony thus far about the utility cost test or the inclusion of the avoided emissions benefit.
Yes, I've been following that.
And I just want to ask you sort of along the lines of the question that that I asked Mr. Alatorre earlier, just in terms of your understanding of the utility cost test. How should avoided emissions, how should we fit that into the utility cost test from I guess a conceptual standpoint?
I think it is part of the avoided costs. In other words, it's part of the savings that you get from energy efficiency and load management measures. So when you save money or save energy, typically you're also saving the greenhouse gases or avoiding the greenhouse gases that go into creating that energy. So that is a real cost. It's a cost that's distributed and a cost on everyone and not just the utility, but it is a real cost and should be considered as one of the avoided monetary costs associated with developing, acquiring, and operating supply side resources.
Okay. And I think what I understood Mr. Alatorre to say, and I might have misinterpreted him, but I thought what I understood him to say is that there's a precedent or there's prior instances essentially under the utility cost test of including benefits that haven't necessarily accrued directly to the utility as part of that test. Do you understand what I'm getting at there? And is that your understanding of how this test has worked before? outside of avoided emissions?
I'm sorry, what was the last part of that? Outside
Just
or alongside?
outside of it, just taking avoided emissions outside of the picture for a second. You know, do you know of any other instance where a benefit that isn't necessarily accruing directly to the utility would be included within this UCT?
Yes, I do. I became, if I may elaborate,
Please do.
I became aware only yesterday doing some research that Zia Natural Gas Company has repeatedly been allowed to count avoided costs of electricity as one of the avoided costs that go into their calculation. Even though they're a gas company, they have nothing to do with electricity. They are counting the avoided cost of electricity as part of their UCT, which of course allows their UCT to be higher.
Okay.
And that's the reason for me introducing these late exhibits today.
Hey, sorry, and is the avoided cost of electricity then sort of kind of like a, I don't know, the trigger for avoided emissions costs? Is that the idea?
Well, not really. They don't really talk about avoided emissions at all. They just talk
Just
about
avoided electricity, just avoided generation capacity.
yes, they talk about avoided energy. You know, and energy could be either electricity or gas, but the avoided energy in this case, you know, the gas company is including the avoided cost of electricity in their calculations.
Is there anywhere else in the regulatory sphere where these emissions are? I guess one of the questions I had is would counting the emissions somehow constitute double counting? Because in other words, we're identifying the electricity, and I understand the electricity has a certain cost, right? And you can say it costs so much to generate so much electricity, but that doesn't necessarily capture emissions. But is there anywhere else in the regulatory arena that we, like I'm thinking of the REA or someplace else where we would be capturing the cost of those emissions?
Not that I know of. I don't see a potential for double counting because I think they're, you know, the way things have historically been done in electricity cases anyway is very concrete costs of avoided energy and avoided capacity. And here we're adding something that considers sort of the externalities of the costs of the emissions, which are separate and on top of the other costs that have already been accounted for.
Did that avoided emissions also encapsulate like embodied emissions that occur with any like by embodied emissions, I'm talking about like, you know, even the production of solar cells itself necessarily entails emissions because you have to have a manufacturing process which creates them. And so therefore within the actual cell itself are embodied emissions. I mean, you know, and I guess on some level the question, again, what I really want to ask you is, where do we stop? Is there any concern about that?
Well, I mean, I think we do need to be careful not to start counting ethereal, unquantifiable costs. But I've read the EPA document that El Paso Electric referenced, and it's apparent to me that only concrete costs like, you know, medical costs and costs of flooding and very tangible explicit costs are included in that cost of carbon, and they make a note that they can't include everything, and they haven't, but they haven't. What they have included is our tangible costs.
A couple other questions for you, Mr. Simpson. And I will go back to this question of the UCT, but just before. When we first started getting into this, you mentioned some of these other exhibits that you've been sent via email, and I had asked you about sort of prior examples or other instances, essentially where the utility cost test would include things beyond sort of the benefit directly to the utility, and you mentioned the Zia natural gas, some cases involving them. I'm not sure that I don't know that we need these admitted into evidence, but can you just tell me what cases you're referring to when you say that there's some other cases where this type of benefit has been allowed? What cases are you referring to?
Just the two Zia natural gas cases. It's 18-00280 is the energy efficiency plan. I guess it's for 2017 to 2019, must be 2016 to 2019. And then there's another case, 22-00222 is again the Zia natural gas energy efficiency and load management plan, this time for 2019 through 2022.
Okay.
I mentioned the more recent application, but I understand that's as an application that hasn't really been vetted or challenged or really scrubbed in any way, that that's probably not worth admitting into evidence.
Okay. Well, I appreciate that. That's helpful information. Just returning back, I guess, to this question of the utility cost test, this issue that I'm trying to wrap my head around, that I think that hearing examiner Ryan has asked about, the UCT. Just from a conceptual standpoint, it seems to me that there's this question, because the utility cost test on the one hand is measuring the monetary costs borne by the utility, right? On the one hand, and then we're going to allow benefits that don't necessarily accrue directly to the utility. Is that conceptually, is that a problem? Should I be concerned about that, or should the commission be concerned about that, I guess, when looking at it that way?
Well, yeah, I have to acknowledge there's some ambiguity there, some potential cause for concern. The way the legislation is worded, the statute is worded, that's a judgment call. Like as I mentioned, what we're talking about are real costs. They're borne by the public and the utility. So, I think the utility has a responsibility to the public and is part of the public. So you could consider it a cost borne by the utility. Certainly the utility will get some of the blame from the public for emissions. So maybe they should include that public cost as part of their cost.
Okay.
It's part of their consideration.
Thank you. And then I guess just one last question, just so that I understand, your argument. If you look at page 11 of your direct testimony, you have a table there, table 1. It's example UCT calculations for air conditioners and heat pumps.
Right.
Do you see that table? I had asked, I believe it was Epe'S witness, Mr. Newman, to walk me through a similar table that he had put together. Can you just explain to me what information you're trying to provide with this table, and essentially how I should be reading it?
Sure. Yeah. Let's start with the first line, UCT. This kind of the standard methodology of calculating this. And by the way, I didn't really have any details from El Paso Electric, so I picked the best numbers I had to calculate these. I think the first line, it's interesting that the AC is, has a higher UCT than the heat pump. I think that's largely because the heat pump has higher incentives, so there's higher costs that are a little bit harder to make, make the UCT more than 1. But again, these are, El Paso Electric's numbers, might be more than 1 when they do this calculation. So the next thing I did was added the, my calculation of the avoided cost of carbon in here. And of course, both numbers go up. But then to me, what was more interesting is this third line, including the avoided cost of natural gas. And when you do that, of course, the AC number doesn't change because you're not really avoiding any natural gas by getting a more efficient air conditioner. But when you replace a gas furnace with a heat pump, that's a huge savings. A heat pump is going to be less than one efficient. It might be 0.6 or 0.8, it might be 60 to 80% efficient. But for a heat pump, the equivalent number to efficiency is the coefficient of performance, and that might be 3 to 5. So it's multiples of several times more efficient than a gas furnace. So you're saving energy, you're avoiding gas usage, even without starting to consider the social cost of carbon. And then this fourth line, when you do start to consider the social cost of carbon, of course, that heat pump number, the UCT just goes through the roof. It almost doubles or more than doubles. And so you can see that for a given incentive, that a heat pump becomes much, much more cost effective when you start to consider the avoided cost of natural gas.
Okay. Okay, I think I understand. Thank you. That's very helpful, Mr. Simpson. And I appreciate you making yourself available for questioning today. I do not have any questions for you. I'm assuming there's in terms of redirect, I guess that is sort of off the table right now. Any further questions from EPE at this time?
No, Mr. Hearing Examiner.
Okay. Any other questions from staff or any of the interveners? Okay, seeing none. Okay, Mr. Simpson, thank you very much for your testimony today. I appreciate it. Is there anything else that you want to address before we, I guess, release you as a witness?
Not this time, sir. I'll look forward to talking later about the exhibits when we get to staff.
Okay, that sounds good. Thank you very much.
Thank you.
Okay, so that I believe will take us to staff's witnesses. Hearing examiner Ryan, should we take our mid-afternoon break at this point, or should we power through one more witness?
No, I would suggest, well, we have Mr. Watara and Christopher Dunn, correct?
Yes.
Let's take our break because the court reporter always appreciates that, and it's the appropriate time to do so.
Okay, that sounds good to me. So I've got 2:33 p.m. We'll be off the record until 2:45. Thank you. Okay, I show that it's 2:45. Before we go back on the record, do we have everybody with us? I show Miss Lynch, and that's about it. Okay. Okay, looks like we have all the attorneys. So I guess at this point, Ms. Hoyman, we can go back on the record. The time is now 2:45 p.m. and we are back from our afternoon recess. Where we left off was the beginning of staff's presentation. So Mr. Friedman, you may call your first witness.
Thank you very much. So I would like to call staff witness Dr. Balmadou Ouattara to the stand.
Okay. Ms. Hoyman, can you please swear in the witness?
Doctor, would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I swear.
Thank you.
Go ahead, Mr. Freeman.
Good afternoon, Dr. Ouattara. Can you please state and spell your name for the record?
Hello, Mr. Ryan. My name is Balmadou Ouattara. Balmadou, B-A-M-A-D-O-U. Ouattara is O-U-A-T-T-A-R-A.
Sorry for the delay there. Do you have a copy of your direct testimony filed in this case?
Yes, I do.
And that should be marked as Staff's Exhibit 1. Is that correct?
Yes.
And would you like to take a moment just to look through it and make sure it is a complete and accurate rendition of the testimony that you previously filed on October 11th of this year?
Yes, it is complete and accurate.
And do you have any corrections that you need to make to this direct testimony?
Sorry, wait, Mr. Ouattara, before you answer, Mr. Friedman, you said that was staff 1. I'm showing in Dropbox, Dr. Ouattara's testimony appears as staff Exhibit 2. Just for clarity.
You
of
are
the
right,
record.
Mr. Hearing Examiner Ryan. I apologize for that.
No, it's all good.
Thank you for the correction.
Yes, it is staff Exhibit 2 is Dr. Ouattara's testimony. Go ahead.
Do you have any corrections that you need to make to your testimony?
No, I have no correction to make to my testimony.
And if you were asked today at this hearing the same questions in your direct testimony, would your answers to those questions remain the same or would they have changed?
Yes, my answer will be the same.
Mr. Hearing Examiner, I move for the admission of Dr. Ouattara's direct testimony to be admitted into the evidentiary record as Staff's Exhibit 2.
Thank you, Mr. Friedman. Any objections to the admission of what's been marked as Staff Exhibit 2? Seeing none, Staff Exhibit 2 is admitted into the record.
And I'll now offer the witness up for cross-examination.
Okay, thank you. Let's see. EPE, Ms. Burns. Good afternoon. Do you have any questions for Dr. Ouattara?
Yes, I do.
Okay, go ahead.
Good afternoon, Dr. Ouattara.
Good afternoon.
It's nice to see you. I just have a couple questions for you regarding your recommendation regarding EPE's utility incentive. And I will direct you to page 9 of your direct testimony.
I'm on page 9.
You're on page 9. Okay. And I'll direct you to page lines 4 through 7.
4 through 7, yes.
Okay. And just to summarize that testimony, there on lines 4 to 7, you testify that in EPE's most recent energy efficiency case number 21-00114 UT, EPE agreed to staff's recommendation to adjust the baseline sliding scale utility incentive from 12 gigawatts to 16 gigawatts, correct?
Yes, that is correct.
Okay, and it's your understanding that the commission in that case ordered that baseline, sliding scale baseline for EP's utility incentive, correct?
Yes, that's correct.
That's correct. And I understand that it's your position in this case that that baseline utility incentive should be increased, correct?
Yes.
Okay. And Dr. Otero, I have no further questions for you. I appreciate your testimony. Thank you very much.
Thank you.
Thank you, Ms. Burns. Ms. Lynch, any questions on behalf of either CCAE or Prosperity Works?
Yes, I do have just a couple of questions.
Okay, go ahead.
Okay. Mr. Otara, please correct me if I'm mispronouncing your name, okay?
Yeah.
Okay. You're aware of the rebuttal testimony submitted by EPE where they increased the budget proposed for the low-income programs, correct?
Yes.
Okay. And do you agree with that increase?
Could you maybe refer me to that rebuttal testimony?
Ms. Burns, could you direct us to the specific page where the rebuttal testimony that EPE submitted points out that it increases the budget for the low-income programs?
Yeah, just give us a minute here. I have Ms. Harris is trying to assist me, but I believe
thank you.
I believe it is here, right? Mr. Otero, we're going to be looking in EPE exhibit number 2.
Okay.
Isn't it here?
Is it that? Okay.
I'll find it. Pages 8 to 9. Right?
Yeah. I'm on page 8.
Right.
That's it.
Do you need a moment to review that, or are you familiar with it?
Please give me a moment to review. So this is EP Exhibit 2, rebuttal testimony of Victor H. Silva, page 8 to 9, right? Could you ask your question again?
Do you, in your opinion, or do you support EPE increasing the low-income program budgets for this energy efficiency plan?
My answer to that would be yes. According to my testimony, staff does not oppose an increase in budget as long as the budget is above the 5% requirement.
Okay. And then in your direct testimony, you stated that your assessment is that while the Energy Saver program pencils out as cost effective as EPE had originally proposed it, with a lower budget. There may be room for improvement in the future. What do you mean by room for improvement?
Which part of my testimony are you referring to? Can you please maybe give me the page and the line number?
Yeah, I didn't, it's, you can turn to page 17 of your direct testimony. And just let me know when you're there.
I'm on page 17, yes.
And
I'm on page 17. So
okay, thank you. I'm sorry I don't have the direct line outlined or identified in my question. But let's see. Do a quick. I'm sorry for wasting anybody's time. I didn't realize that this was not identified. Let's see. Room for improvement.
Excuse me, Ms. Lynch, it's page 19, line 2.
Thank you. I appreciate the assistance. Can you please turn to page 19 of your testimony?
Yes, so I see where you're referring. So basically, this was in this part of my testimony, I say that in recent years, the program has shown higher UCT values with an average of 1.61 from 2020 to 2023. The projected decline in UCT is noteworthy, but does not detract from the positive impact of this program for low-income customers moving forward. However, while still cost-effective, this indicates there may be room for improvement in the future. So by room for improvement, I'm referring to the projected average UCT of 1.4, which is less than the historical 161. So basically here, I believe that the company can still do better, like in order to move closer to the historical UCT, like which is 1.61. However, 1.4 like is still higher than 1, so the program like is still cost effective. So this is what I was trying to explain in this paragraph.
Okay. And you are aware of the percent of individuals who live at 200% of poverty level in EP territory?
I don't have that number in mind.
Okay. Hearing examiner, that is the extent of my questioning for this witness.
Okay, thank you, Ms. Lynch. Mr. Simpson, I believe that brings us to you. Do you have any questions for Dr. Watar?
No, I do not. Thank you.
Okay, thank you. And I believe that's all of the parties. Hearing examiner Ryan, do you have any questions for Dr. Watar?
No.
Okay. Thank you. Good afternoon, Dr. Watara.
Good afternoon.
I only have maybe one or maybe a series of questions based on your answer to my question, but one of the issues that you testified to in your direct testimony, and we've heard testimony about it all day today, is this incentive mechanism the EPE has proposed and that's consistent with what was approved by the commission for its previous energy efficiency case. And I'm hoping that you can provide a little bit of clarity to me as far as how I should be thinking about this issue. If you look at page 9 of your direct testimony,
okay. I'm on
And
page 9.
okay, and I just wanted to ask you just to provide me a little bit more explanatory detail. If you look from lines 11 to 13, you say that the final order in case number 21-00114-UT mandated that EPE adopt the sliding scale incentive mechanism it proposed, but with the staff recommended adjustment to start the baseline incentive at 16 gigawatt hours instead of 12. Can you explain to me how that sliding scale incentive structure worked?
So the sliding scale like incentive structure basically rewards EPE a baseline incentive of 6.6% of plan year program for verified annual savings. Now, the verified annual savings like is agreed upon between the parties and the commission and EPE. So for that particular year, the proposed annual savings by EPE was 12 gigawatt hour. And in the recommended decision, like it was agreed that instead of 12 gigawatt hour, like it will be 16 gigawatt hour. So EPE will be rewarded a baseline incentive of 6.6% of plan year program costs for verified annual saving of at least 16 gigawatt hour with an added incentive of 0.075% for each 1 gigawatt hour of seasonal energy savings up to a maximum of 7.18%. So this is the incentive structure.
Okay. So they have to have at least 16 gigawatt hours, and then every gigawatt hour above that, then they get an additional incentive.
Yes. And
Okay.
that additional incentive is 0.075%.
Right. And EPE wants to continue, EPE's proposal is to continue that same incentive structure, correct?
Yes, that's what they're proposing in this final.
Okay. And you're proposing a change?
Yes.
Okay. Can you tell me how your proposal would change theirs and why you think that change is appropriate?
So my proposal of 19 gigawatt hour is based on EPE being able to attain the 2025 goals of 78.5. Let me just check on that real quick. So, yeah. No. The EU goal in 2025 is actually 78.872.865. So in 2024, the cumulative savings attained by EPE was 60 gigawatt hour. So when you do a difference here between 60 gigawatt hour and the goal of next year, 78.8, so this comes to a difference of 18.87 gigawatt hour. So based on that difference, we are proposing that EPE set the annual savings for 2025 to 19 gigawatt hours, so which is just an approximation of 18.87 gigawatt hour. So this is how we get the 19 gigawatt hour from.
Okay.
So it,
please continue.
Yeah, it's based on the difference of like where the company is right now in terms of its cumulative savings compared to the EU goal of 2025. So like if we go by 16 gigawatt hour, the company will not be able to reach the EU goal in 2025. So like if that's what the annual savings of 2025 will be.
Okay. So in other words, they should not, at least what you're arguing is that they shouldn't be provided an incentive if they're not going to meet that target that's in statute.
Yes, that's what I'm proposing.
Okay. Now, if I'm not mistaken, I thought that I heard, and I believe this was maybe Adrian Hernandez from EPE. I believe that he testified It's possible I'm attributing testimony to him that was from Mr. Silva, but I thought it was Mr. Hernandez who essentially responded to that proposal and said that was essentially going to be penalizing EPE for circumstances beyond its control in 2022. Do you remember testimony along those lines, and how would you respond to that?
Yes, like I do remember that argument. So my response to that is that staff is not trying to penalize EPE by suggesting like a 19 gigawatt hour saving. So our proposal here is basically based like on the statute and what is required to meet the EU EA target. And it is our understanding that if the company notice that like it will be hard or impossible to meet the target, the company had the chance to file for a variance, and that is based on the 62-17-5 that H rule, which state that a public utility that determines it cannot achieve the minimum requirement established in subsection G of this section shall report to the Commission on why it cannot meet those requirements and shall propose alternative requirement based on acquiring cost-effective and achievable energy efficiency and load management resources. And to our knowledge, that is not what the company did, or they have not filed for like any variance so far, or they have not like informed the Commission that like it will be impossible to reach the minimum requirement. And here the minimum requirement in order to achieve the EU EA goal by 2025, I believe is 18.87 gigawatt hour.
Okay, I think I might come back to that, but
Okay.
just to put a finer point on what you're arguing and the staff's position, you're arguing essentially that they could have previously filed for a variance when they couldn't reach their target. Is that in 2022? Is that when they ostensibly should have been filing for a variance? Would have been in 2022?
I don't know exactly which when the variance like has to be filed, but I believe that according to the statute, that's something that should be done like if the company is confident, like the company believes that they won't be able to meet the requirement. However, I have to say that like in their filing, the company argues that they still believe that they will be able to meet the requirement in 2025.
Okay, now let me ask you about that. So you may have just testified to this, but this difference in terms of the incentive level, EPE is requesting that the incentives remain the same as it was set in their prior case. You're recommending that it be increased up to 19. Let's say the commission thinks that they need to stick with the previous incentive structure. That's what EPE does. They meet that, they get that incentive. How far short would they then fall of the total number that they needed to hit by 2025?
We can actually do the math for that. I believe it will be the difference between 78.872 and 76.9. And I think that will be about, I can quickly do the math and give you like a result, but that will be about 1.9 gigawatt hour difference.
Okay. Okay, that's helpful. I don't have any further questions for you, Dr. Watara. I do appreciate your testimony. Hearing examiner Ryan, any questions prompted by my questions? Okay. Let's see. So that takes us to Mr. Friedman. Any questions on redirect, sir?
No, thank you.
Okay. Ms. Burns, any questions on recross from EPE?
No, sir.
Okay. And Any of the, either, I guess, of the remaining interveners, Ms. Lynch, Mr. Simpson, any questions on recross?
No, sir.
No, thank you.
Okay, thank you. Well, I believe, Dr. Watara, that concludes your testimony here today. We do appreciate you coming and testifying. So thank you very much, sir.
Thank you.
Thank you. And Mr. Friedman, on to you, I believe, for your second and final witness.
Yes, so I'll call to the stand Mr. Christopher Dunn,
Okay.
Utility Division staff.
Good afternoon, Mr. Dunn.
Good afternoon.
Ms. Hoyman, if you would please swear in the witness.
Mr. Dunn, do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Please go
Absolutely.
ahead, Mr. Freeman.
Good afternoon, Mr. Dunn. Can you just state your name and spell it for the record?
Yes, absolutely. My name is Christopher Dunn, CHRISTOPHER. Last name Dunn, DUNN.
And do you have a copy of your corrected direct testimony that you filed in this case, marked as Staff's Exhibit 1?
Yes, I do.
And would you like to take a moment just to look through it, make sure it's the complete and accurate rendition of the testimony previously filed on October 16th of this year?
Here, it appears that this is a complete and accurate version of my testimony, yes.
And do you have any corrections that you would like to make to this corrected direct testimony?
Yes, if I may, I'd like to offer a single correction. I would direct attention to page 36 of my corrected prepared direct testimony, and specifically looking at beginning at line 10, going into line 12. The sentence states EPE provided updated estimated bill impacts to reflect these changes in response to staff's discovery and filed an errata to its application reflecting this change on, then there's multiple X's. I would like to strike the language after the word discovery. So strike the language and filed an errata to its application reflecting this change on XXXXXXXX. And I would like to replace that with a comma, a copy of which is included as exhibit CED-7, period. With that, that is the only correction I would like to make to this corrected direct testimony.
Mr. Hearing Zimmer, do you need anything else for that to be corrected from staff as far as post-hearing filings or anything?
Well, as long as, I mean, we may be getting the cart in front of the horse. I'm assuming that the exhibit will come in, but assuming that it does, then yes, I think what we'll do, just to be consistent with, I think at least two other exhibits so far today, I'll ask you to upload a corrected exhibit into Dropbox, and then I'll have to clear out the older version before it goes to the court reporter.
All right. Yeah, just before I moved on, I wanted to see if you would like any other information regarding that edit. So with that being,
that's the information I need, but then the corrected exhibit will put in Dropbox.
Right, well, with that being said, I'll move for the admission of Mr. Dunn's corrected direct testimony with further corrections, as just mentioned, to be admitted into evidentiary record, Staff's Exhibit 1.
Okay. Let's see. Are there any objections to the admission of Staff Exhibit 1 as it has been corrected here today? Ms. Burns?
No objection.
Okay. Any objection from any of the interveners? Okay. Seeing none, Staff's Exhibit 1, as corrected here today, is admitted into the record. And Mr. Friedman, after the hearing today, if you could upload a corrected exhibit, that would be very helpful.
And I will now offer the witness up for cross-examination.
Okay, thank you. And I guess turning first to EPE, Ms. Burns, do you have any questions for Mr. Dunn?
Yeah, I have just a few questions.
Absolutely, go ahead.
Good afternoon, Mr. Dunn.
Hello, Ms. Burns.
I'd like to thank you for your testimony today. I just have a few questions regarding staff's recommendation for additional reporting on EPE's residential products program. And
Certainly.
your recommendation, it starts at the bottom of page 23 of your direct testimony. And then it goes for several pages.
Yes, I've directed my attention to page 23.
All right. And so I just want to ask you a few questions regarding your recommendation that's set forth on page 24. But before I do so, I'm assuming that you have read and are familiar with EPE's rebuttal testimony in this case?
I've reviewed EP's rebuttal testimony in this case, yes.
And specifically, you have reviewed EP witness Victor Silva's rebuttal testimony in this case?
I've reviewed witness Silva's rebuttal testimony in this case, yes.
And so you understand his response to your recommendation regarding EPE's residential products program. Is that correct?
I think generally speaking, yes, but if I could ask you to please refer me to a page and line number so that I can confirm that I am considering the same thing that you're wishing to direct me to.
Sure, yeah, sure. But before we do that, I'd like to direct you to lines 13 through 19 on page 24 of your direct testimony.
Certainly, you would like to direct me there before presenting clarification?
I would. And before I ask you questions regarding your recommendation, you would agree with me that the current regulations don't require EPE to report in its annual report at measure level. Isn't that correct?
I believe that the portfolio programs is evaluated at the portfolio level. I believe EPE provides measure level information. I believe, though, that the portfolio is a level that the filing is evaluated at.
Yeah, at cost effectiveness, right? The regulations, would you agree with me? The current regulations require cost effectiveness to be done at the portfolio and at the program level.
The current regulations require that it's evaluated at the portfolio level. Program level evaluations are also conducted, but there are instances wherein the commission has permitted for programs that are not cost effective as measured by the UCT to be incorporated into the broader portfolio, so long as the portfolio as a whole is cost effective as demonstrated by the UCT.
Right, and because the regulation require cost effectiveness evaluations at the program level and at the portfolio level, you're making a specific recommendation in this instance for a change in that requirement, correct?
That's incorrect. Staff simply recommending in this instance that rather than only providing an evaluation of what EPE is termed as a residential products program, in conducting that evaluation, the evaluator that is, as we discussed earlier with other witnesses, assigned by the commission after an RFP to select that evaluator. That evaluator looks at all the different measures, and they use a variety of different mechanisms to conduct the UCT evaluations. Some of them are done on direct installs based on things basically saying, okay, there's this much square footage in a room, we have this many lights, and then we infer these savings. Some of them are more directly measured. And so what staff is recommending is that just like in any program, how you build up the overall cost effectiveness determination by evaluating the cost effectiveness of these measures and then coming up with a program level evaluation of UCT, that in this, you're already going to have those measures if you're El Paso Electric in order to evaluate the residential products program. Simply take those measures that are already conducted and then split them up to evaluate the residential lighting program as it was created prior to this and stands alone, assigning in a relative manner the costs of things such as administrative costs to the lighting measures, and then measure again, since you already have those measures based on the evaluation of the evaluator that is assigned by the commission to evaluate that residential products program, you simply partition off as well the new measures, the residential products measures, and then you evaluate those. There's nothing necessarily new or novel about staff's recommendation. And if I can just finish that, there's nothing new or novel about staff's recommendation. We're not requiring anything new to be done. We're simply asking that there's a reorganization of the information that El Paso Electric will already have available to it.
But Mr. Dunn, isn't it true that if EPE was already required to report this information at this level in its annual reports, you would not need to have made this recommendation to the commission?
I think that you're misconstruing what I'm saying. I'm saying EPE will already have this information based on what it provides in its annual reports. To say that EPE is being required to do something new is inaccurate and not correct with what staff's recommending. We're just saying reorganize that information that's already at the company's disposal and take that spreadsheet, put some different columns in it, and provide the information that staff's requesting. There's nothing new that's being.
And Mr. Dunn, you're familiar with EPE's annual reports, correct? It's annual
Yes,
energy efficiency reports.
I believe I've indicated as much, yes.
Yeah, you are. And the information that you're requesting to be reported on an annual basis is currently not provided in the format you're requesting in those annual reports, correct?
The residential products program doesn't exist yet, so it's not provided. That's correct.
And isn't it true that EP's annual energy efficiency and load management report does not report cost effectiveness for measures?
Cost effectiveness is evaluated on a program and portfolio level.
Okay, and that's part of what you're requesting in your direct testimony, correct?
Because EPE will already have the information to determine the cost effectiveness of a program, this will be a simple matter of mathematics that the company can also conduct without necessitating any excessive additional costs. I believe to state otherwise is incorrect because that available information is already available to the company and it simply must be presented in a different way.
But
so I think I'm sorry, if I can, if I may finish my response.
Excuse me?
If I may finish my response before being directed to a new question, please. So again, as I was stating, EPE is not being asked to provide any information that they otherwise do not have. They are simply being asked to reorganize that information so that the company can evaluate this program that the company has proposed, so that the commission can evaluate this program the company has proposed because it is including measures such as lighting that are already widely adopted. And so staff wants to see, okay, if this program is being proposed for changes by the company, then let's evaluate it so that we really understand, are we getting the most bang for our buck, so to speak, with the dollars that are going into this program when we're funding measures such as lighting that, as we know, are already widely adopted and as is indicated in EPE's own reports that are widely adopted among its customer base, such that we can determine whether or not this program is cost effective and reasonable for our customers. Right. There's no new information that'll be necessary.
And you've testified that you've read EPE's rebuttal testimony on this in this case, right?
Yes, I did ask for a direction though to which area you were looking for me to consider though.
So if you go to Mr. Silva's rebuttal testimony page, and that would be EP Exhibit 2, page 5 to 6.
I'm at EP rebuttal testimony, Victor Silva at page 5.
Are you there, Mr. Dunn?
Yes.
Have you had an opportunity to review Q10 and EP's response, Mr. Silva's response to Q10 on page 5 and 6?
No, I haven't. I was waiting on you. I indicated I was at page 5. I will review that now.
Thank you.
All right, I've completed reading that Q&A.
Yeah, and based on what you've testified to this afternoon, I think you're in agreement with Mr. Silva that evaluation is required to be done at the program and portfolio level, correct?
I agree that that's how the commission evaluates the cost effectiveness of programs is at the program level, and the cost effectiveness of the product portfolio is at the portfolio level. As a component of that, in order to make those determinations, measure level evaluations must be conducted. Otherwise, you have nothing to build up those evaluations.
Mr. Dunn, I think you're in agreement with EPE.
I'm sorry, I'm still concluding my question, Ms. Burns. If I could be allowed to conclude my response to your question.
I think your answer is going quite a bit beyond my question, Mr. Dunn.
Here's what I would like to interject and say something. I want to know, what is the distinction between the measured level reporting and the portfolio level reporting in a concrete sense, just so that I understand the nature of the disagreement? Mr. Dunn, maybe you can give an example, if you just mind.
Yeah, absolutely. So when you're looking at the measures, you're looking at something, for example, say, you might look at a more energy efficient refrigerator or a smart thermostat, and you're looking at, for the dollars that we spend on this individual measure, are the benefits outweighing the costs? And so, when you're making a program level evaluation or a portfolio level evaluation, you must look at, okay, how many measures were deployed? What is the relative cost effectiveness of those measures? And you're going up from a bottom up perspective and building then that evaluation of programs and portfolios.
And if I understand correctly, the testimony to which Ms. Burns originally pointed you, which was your own testimony, that was discussing residential lighting LED measures. And the recommendation there was to be more granular with how those specific LED lighting measures will all play out. Is that what this is about?
Yeah, essentially, EPE in its application is asked to rename a residential lighting program to the residential products program. And rather than eliminating or reallocating the funding for the residential lightings program, they can seek to continue that program under a new name with additional measures. Staff is simply recognizing that part of the reason that El Paso Electric, I believe, is doing this is because residential lighting is becoming a smaller component of utilities' energy efficiency portfolios. This is largely based on federal standards that have been basically a finalized rulemaking that reinstated the 45 watts per lumen or 45 lumens per watt requirement for general service lamps and expanded the definition of general service lamps, such that essentially utilities are able to get less savings out of a foundational energy efficiency program for quite some time now, which is lighting. And so rather than redirect those dollars to other programs, the company has chosen to rename the lighting program to the residential products program and include new measures. And staff is simply saying, look, if you're going to be doing that, then why don't we really evaluate these measures and look at things as if they were two programs? If you had those residential products on their own, let's evaluate that, and the residential lighting on its own, and let's evaluate that. Still present us with the original residential products evaluation as you intended to, and then give us these kind of sub-evaluations too, so we can see what's really driving the cost effectiveness of this. Because with these changes to the requirements for lighting, and with the widespread adoption of efficient lighting resources, it is likely to be the case that it is less and less necessary to incentivize customers through energy efficiency programs that are funded through ratepayer dollars to change to more efficient lighting. If those customers intended to change to that more efficient lighting from their existing lighting sources, they already have access to it. And so do we
And
really
those-
need to continue to fund these
those-
programs?
Those lightings, are we talking, it's not street lighting, we're talking truly residential, like household lighting?
Correct.
Okay. Okay, I'm sorry to interject there. I just needed to have clarity on what the debate was about. Ms. Burns, that's back to you.
Thank you. I guess, just in the spirit of speeding this along, do you understand that EP has committed in response to your annual reporting requirement recommendation that EP here on page 6, line 4 to 7, has committed to give you all the information that you would want to require and evaluate regarding your proposal?
No, I understand it says EPE can commit to work with staff outside of the formal reporting requirements to provide staff with additional measure-specific information. That's not really what I'm looking for. I would like for there to be a commitment that as part of the formal reporting requirement, that all parties are going to have an opportunity to evaluate this, because this concept that we just need to keep on funding, through ratepayer dollars, the customers to make a switch to efficient lighting through these programs, I'm not sure that that's justified. And I think that EPE's response here falls short of what staff is hoping for.
All right. So even though staff agrees to give, EP agrees to give staff the required information, staff thinks that this information should be reported in its annual report so other parties can have this information also.
Yes, I think it should be formalized rather than an informal approach that has been proposed here.
Okay. And okay, I have no further questions. Thank you, Mr. Dunn.
Before I move on, I just want to follow up on that, just so that I understand the point that you're making, Mr. Dunn. So the benefit of a formal report would be that other parties are able to access that information. Can you elaborate any more? Is there any other benefit that the commission should consider in terms of what formal reporting would accomplish?
Yeah, absolutely. I think that ultimately in all of these efforts here, we're recognizing that, these are ratepayer dollars that are ultimately going into these programs. And so I think that it's important that other parties have an opportunity to review the formal reporting that staff is requesting here, such that they can make judgments on whether or not is it appropriate to continue to offer measures and programs that are of this nature. I think that is particularly important as we recognize that costs in general to serve customers or customer rates have been on an increase. And as we reflect on how do we really incorporate all of the general policy objectives that we have as a state, with things such as the energy transition, transportation, electrification, energy efficiency goals. There are a multitude of goals that have a general effect of increasing customer rates for the ongoing provision of safe and reliable service. And staff is simply making a point here that in a program like residential products, which is a rebranded residential lighting program with a few new measures, we should consider and evaluate whether or not this is the best use of ratepayer dollars to go to fund the transition away from inefficient lighting to efficient lighting, when EPE's own reporting shows that the majority of their customers already have efficient lighting sources for the majority of lighting that they have in their homes or places of service. So I think that the benefit is not just formalizing it so it exists. The benefit is formalizing so it exists so that parties can evaluate whether or not this is an effective use of ratepayer dollars.
Okay, thank you. I appreciate that. So with EPE having concluded its cross, then that takes us to you, Ms. Lynch, and CCAE. Any questions for Mr. Dunn?
Yes, hearing examiner, we have a few questions.
Okay, go ahead.
Let me navigate to those. sorry, because here, Mr. DeSalin was gone. He
He's
had sent
he's
me
in the
these
waiting room.
questions. Oh, he is?
He is. I am letting him in now. So if you intended for him to
Great.
do it, then he's here.
Yeah, I mean, I was gonna ask questions for him, but he is here, and it looks like he could maybe handle these questions.
Welcome back, Mr. DeSalin. How do you feel about cross-examining Mr. Dunn right now?
Thank you, Mr. Hearing Examiner. I think I'm ready to do so.
Okay. The floor is yours.
Thank you. Good afternoon, Mr. Dunn. My name is Charles DeSalin, and I'm representing Coalition for Clean Affordable Energy. And I just have a few questions for you that go to the question of the including the avoided costs of emissions in the utility cost test.
Mr. DeSalin, can I pause for just 1 second? And
yes.
That is exactly what I hoped you would talk about. But can I just have Mr. Dunn do something before you do that? I think it'll be useful to all of us because it'll kind of orient me. And then it'll give us Mr. Dunn's thoughts about particular words of the statute, right? So page 13 of your direct, Mr. Dunn, you identify the terms of the statute, and you note there, and I'll assume this is a correct direct quotation of the actual statutory source. The Efficient Use of Energy Act defines the utility cost test as, and I've been reading this over and over and over as people have been talking, and I've been trying to understand it. But I think if it gets boiled down to this, I'm going to paraphrase a little bit, but I'm just going to, a standard that is met if the monetary cost borne by the public utility for energy efficiency are less than the avoided monetary costs associated with developing, acquiring, operating supply-side resources. So in other words, monetary costs to do efficiency must be less than monetary costs to supply resources to meet the need otherwise. And so tell me, Mr. Dunn, that language precludes the avoided emissions test because, and you finish the rest of that.
I think staff would say that language makes it necessary to evaluate whether or not the utility cost test should include an emissions benefit in the context of a rulemaking.
Okay, but so are you arguing then that, because my question was going to be something along the lines of, does the word monetary costs or the phrase monetary costs in the developing, acquiring, operating supply side resources, we heard Ms. Lynch earlier say, isn't not generating necessarily reducing emissions, and on some of what seems intuitive. So monetary costs, is that big enough to include the externality costs associated with emissions?
I think that's an important and very significant point for the commission to consider that is better done outside of the context of this particular case. I will point to the fact that within its statement of briefing issues or agreed upon facts that El Paso Electric Company supplied, they did reference a recommended decision that came out of a PNM case. And I thought it rather interesting that in their reference to that PNM case, they indicated that basically the program costs, they had a parenthetical that was all EE/LM program related expenses that went into the denominator. But they didn't include the parenthetical about what went into the numerator, which was the supply side benefited or supply side benefits or avoided costs. And the parenthetical that was not included said, also known as system benefits or costs to serve. Now, it is unclear to staff if an avoided emissions benefit is a direct cost to serve. If we are going to be taxing pollutants and identifying these additional costs and including those externalities, I believe that the commission should evaluate in a rulemaking, because this will be something that will have an effect on the other investor-owned utilities as well, not just El Paso Electric, whether or not it is appropriate to include that avoided emissions benefit. I think there was a really good example that was brought up earlier when discussing smart students. And there was a discussion of, well, currently using the existing UCT measures, the smart students program is at roughly a 0.75 UCT. But if we include an avoided emissions benefit, all of a sudden it raises to above 1.0, meaning now it's cost effective. And so what that means in my mind is, let's say that you have another measure. We'll just say, efficient refrigerators, and that measure has a 1.5 UCT. And now all of a sudden we're looking at, or we can look at it at a program level. The residential comprehensive program, I'm going to give an arbitrary number, has a 1.5 UCT. And the smart students program has a 0.75 UCT. So now when we're thinking about where do we put our dollars, if we include that avoided emissions benefit, and now all of a sudden that smart students program bumps up, now it makes more sense to put dollars in there. But we know either way, avoided emissions benefit or not, the residential comprehensive program, we get more bang for the buck. We get to put $1 in, we get $1.50 worth of value. We don't get that with the smart students program unless we add this avoided emissions benefit. Then all of a sudden it looks a lot better. And again, staff looking at our considerations of these are ratepayer dollars that are funding these programs. I think we need to carefully evaluate before we just include an avoided emissions benefit. Does this really affect the customers, the ratepayers, the folks that are going to be actually enjoying the benefits of utilizing these programs, relative to what are the actual implications of what are we missing out on if we allow these programs? I think it was described earlier, makes it a little bit easier for them to get into the portfolio. So that's what I'm really looking at.
Yeah, and I guess I'll rephrase all that and maybe just see if you agree with what I'm just about to say. So in other words, even though the words avoided monetary costs could encapsulate avoided emissions and any dollars we could put with those, doing so necessarily embeds within the analysis the potentiality for distortion that would be contrary to the public interest.
It's possible, yes.
Thank you. Go ahead, Mr. DeSalen.
Hang on, Mr. DeSalen. One quick point on this issue about the avoided emissions benefit. I was going to ask this later, but I want to ask it now. Mr. Dunn, you just testified about staff is urging the commission to resolve this issue through a rulemaking proceeding instead of a contested proceeding like this one, a particular adjudication. One of the questions that I have been trying to wrap my head around as I've been reviewing your testimony is this question about, is this a question of law or is this essentially a policy question? And what I think I'm understanding from your testimony is that there is both a legal question here and a policy question as to whether this can be done legally and whether it should be done. Am I looking at that issue correctly from your perspective on the staff side?
Yes, hearing examiner, I believe you understand my position correctly.
Okay, excellent. Please go ahead, Mr. DeSalen.
Thank you. And I'm Mr. Dunn, I'm going to try to avoid getting into the legal questions here because we will be addressing that in our post-hearing brief. So I'm going to focus mostly on the economics question, and it shouldn't take very long. So first of all, if we could look at page 13 of your direct testimony, beginning on line 6, you state, and I think this has probably already been established, that commission staff does not support the inclusion of the avoided emission benefit in El Paso Electric's calculation of the UCT, and I take it that is still your testimony.
That is still my testimony, yes.
Okay. Now, I have a few questions about how that the inclusion of the cost of avoided greenhouse gas emissions in the UCT calculation. you testified that you are an economist, I believe, right?
Yes,
And so you are familiar with the concept of external cost as it's used in the economics context.
I'm familiar with the principle of externalities. Yes.
Okay. And an external cost, as I understand it, is a cost that is associated with producing a particular good or service, um, but that cost is not reflected in the price of the good or service. Is that correct?
I'm okay with moving on with your definition. I'm not necessarily going to say that that's my definition, but I understand what you're driving at.
Okay. Do you think that is an accurate definition from an economic standpoint?
Can you state it for me again?
Yeah. It is a cost associated with producing a particular good or service that is not reflected in the price of that good or service.
I believe that that could be one appropriate definition.
Okay. So the external cost is borne by another party, the public at large, or perhaps a portion of the public. Is that correct?
Mr. DeSalen, could you direct me to the area of my testimony wherein I discuss externalities and their relevance to this particular concern?
Well, I don't think you do discuss externalities, but I think the basis of your opinion is hinges on externalities.
I think that the basis of my opinion hinges on the importance of a rulemaking in order to evaluate the relevance of these concerns and to determine whether or not those concerns should be included in the evaluation of the UCT. I've heard the Commission in recent open meetings discuss the importance of the fact that the UCT has been established for some time now, and to some degree, the Commission is wary to open up the can of worms of evaluating the UCT on a singular issue. And I think that that's what this would have the effect of doing, would be evaluating the calculation of the UCT on the basis of a singular issue. I believe rather than doing so in a context that would thereafter apply to other investor-owned utilities, not just El Paso Electric, we should, rather than do so in the context of this case, we should evaluate in the context of the rulemaking.
But you would agree, would you not, that the effort of or the proposal of El Paso Electric Company in this case is to internalize some of the externalities that are involved with its energy efficiency projects?
I understand that that's the intent based on the company's application. However, my analysis of this recommendation that has been proposed by staff is not based on an evaluation of those facts. My analysis is based on an evaluation of the appropriate means to be able to determine the UCT, and that's based in the context of a rulemaking that will make this not a singular issue determined solely for EPE, but would consider the fact that this will also have implications for ratepayers and the other investor-owned utilities.
Okay, but the commission has the authority, nevertheless, to address the issue in an individual case. You agree with that, don't you?
Because I'm not a legal expert, I'm not going to evaluate where the commission's authority lies and where it is.
That's fine. I'm sorry. But as an economist, externalities are viewed as a distortion of the market. Isn't that correct?
That did not go into my evaluation in this case.
I'm sorry?
That did not go into my evaluation in this.
But is that nevertheless the case?
I'd like to object. I think Mr. Dunn answered that question, and I question if we're going beyond the scope of Mr. Dunn's testimony at this time.
Okay. Mr. DeSalen, how do you respond?
Yes, I think that the whole concept here of externalities is a crucial part of Mr. Dunn's testimony. Externalities go to the heart of whether the UCT test, as it was prepared by El Paso Electric, is adequate or not.
Well, Mr. DeSalen, I mean, to Mr. Dunn's point, I don't see in his direct testimony where he discusses externalities. I mean, I understand your argument and I understand conceptually how it potentially fits in, but he has testified here, I think repeatedly, that he did not base his opinion in this case off of that economic concept. And I'm not seeing it in his direct testimony. Am I missing anything?
Nope, it's not in there, at least not directly, but I think it is in there certainly indirectly.
Well, Mr. DeSalen, can I just ask you to clarify? I mean, it's your position on, I mean this by the party, not just your factual presentation, but that the term monetary costs within the definition of the UCT within the Efficient Use of Energy Act, the words monetary costs do include externalities?
Certainly. Yes, Mr. Hearing Examiner. And we will address that in our post-hearing brief. I have no further questions than Mr. Dunn. Thank you very much.
Okay, thank you. I believe that takes us to Mr. Simpson. Mr. Simpson, do you have any questions for Mr. Dunn?
Yes, I do. Can you hear me? I switched my audio to my headphones.
We can hear you. Go ahead.
Okay, great. Good afternoon, Mr. Dunn. I just have a couple of questions.
Absolutely.
Let me take you to your direct testimony, page 13, which we probably are already there.
Yes, sir.
And it as we've discussed, staff does not support the inclusion of an avoided emissions benefit, correct?
Correct.
Okay. You've mentioned you really prefer rulemaking as the process to change the way UCT is calculated, correct?
I believe that this matter would be evaluated better in a context of a rulemaking. Yes, sir.
Do you think that revisions in the way UCT is calculated could be addressed outside of rulemaking, for example, in a case before the PRC?
I cannot, as I indicated previously, it's not my area of expertise to opine on whether or not the commission has a legal authority to direct the revisions to the UCT calculations within the context of a particular case or rulemaking. I believe that it is best done within the context of rulemaking.
Okay, thank you. I'd like to refer you to Simpson Exhibit 3, which is one of the exhibits I emailed early this morning. Do you have that exhibit?
I apologize, Mr. Simpson. When I downloaded the links from Dropbox, that one was not included, but I believe that I did see your email come through earlier. So if you'll give me just a moment, I believe I will be able to identify it.
Great. Yeah, that was the one early this morning, maybe 8 o'clock or so, somewhere around there.
Certainly. I see Simpson Exhibit 3, which, as I open it up, appears to be the recommended decision in case 18-00280-UT in the matter of Zia Gas Company's energy efficiency program.
Okay, and that's for 2019 to 2021, correct?
It appears to be the case.
Okay, let's go to page 13 of that document, which is, I think it's page 15 out of 31 PDF pages.
I'm there.
PDF page 15. Okay, so can you read the title and the first subheading at the top of the page?
Yes, sir.
Sorry, could you read that out loud for us, please?
D period, description of Zia's existing energy efficiency measures and proposed changes to the measures. 1 period, space heating measure.
Thank you. And then can you also read out loud the last row in the table on that same page?
Excuse me, I'm not following. Are we on page 17 or 15?
It's page 13,
Oh, 13, okay.
which is PDF page 15 electronically.
Oh, okay. I'm sorry. I don't have the PDF. Thank you.
Yeah, I was just asking you to read the last row out loud, please.
The last row of the first column of that table indicates upgrade from electric resistive heat to natural gas forced air heat of AFUE 95% or higher.
Okay, thank you. And then let's go 3 more pages to page 16.
I'm there.
Okay, so I'd like you to read the last 2 paragraphs of this page because I think it's important and relevant to this case.
Slowly, please.
Am I being
Yes,
asked
could
to
you
read
read it? Yes, I'm asking you to read it out loud, please.
The holding from case number 12-00317-UT should be followed in this case, and electric savings from ZIA's space heating measures should be counted as benefits in the UCT calculation. The Commission's reasoning in case number 12-00317-UT, while involving the TRC calculation, applies equally to the UCT calculation. The EUEA's mandate, quote, the Commission shall direct public utilities to evaluate and implement cost-effective programs that reduce energy demand and consumption, end quote, has not changed. The EUEA today still contains that mandate to reduce energy demand and consumption overall. NMSA 1978-62-17-5B. Next paragraph. ZIA should be required to revise its 2019 through 2021 program to continue offering a rebate for upgrading from electric resistive heat to natural gas forced air heat.
Thank you. So do you think the same logic could apply in this case, that gas savings from El Paso Electric measures like heat pumps should be counted as benefits in the UCT calculations in the same way the PRC ruled that electric savings be included in the UCT for this gas company?
Mr. Simpson, I'm going to need a moment having read that aloud for the reporter. Comprehension does not always go hand in hand when you're trying to do that in a slow and effective manner. In order for them to get that information, I'm going to need a moment to reread this so that I can consider it. And then I'm going to ask you to restate your question, if you will.
Okay.
Mr. Simpson, may I ask you to restate your question now?
Yes. Do you think the same logic should apply in this case, that gas savings from El Paso Electric measures like heat pumps should be counted as benefits in the UC calculation in the same way the PRC ruled that electric savings be included in the UCT for measures for this gas company?
Mr. Simpson, I would ask you to direct me to the area of my testimony that this covers, because I believe that I have made such an evaluation in my testimony, and I'm not prepared on the basis of reading a singular paragraph that references cases dating back to 2012 and utilizes the TRC test, a test which the Commission no longer utilizes in its references. I cannot be asked fairly, I believe, to make an inference based on that single paragraph in the sentence thereafter about the appropriateness of including those recommendations within the context of this particular case. If you are able to direct me to a particular area in my testimony where I opine on this matter, I will be happy to address that further.
Well, no, I don't think you opined specifically on this matter, but it is, you did testify about UCT calculations. And this is a prior PRC ruling that is also about UCT calculations. And I would point you to the fourth line of the first paragraph that you read, that it is applies equally to the UCT calculation, not the TRC. So rereading that paragraph that does apply to we are talking about the UCT here. And you did testify about the UCT. Can you see let me ask you this, I guess, can you see the logic in counting gas savings for an electric utility when the PRC has accepted counting electric savings for a gas utility?
Well, I appreciate the relevance of this particular paragraph, Mr. Simpson. I am not at this moment prepared to give you a recommendation on whether or not the logic follows and applies to this case. This document was presented to staff at earliest at this morning, and it is numerous pages. And so I'm not willing to pick out a singular paragraph and determine whether or not the logic applies in this context.
Okay, thank you. Why don't we move on in the interest of time? Let's I also after discussion this morning, and I realized that it was probably not appropriate to include the application from Zia Natural Gas Company in 24-00247, since that is probably not appropriate to introduce into evidence, even though it does point to the currency of this measure, this space heating measure for electric resistive heating being replaced by gas heating. Around lunchtime, I sent out another set of exhibits, including Simpson exhibit number 5. Do you have that exhibit accessible? It was also sent out an email.
I'm opening it now. I see Simpson Exhibit 5 to be recommended decision in order shortening deadline for exceptions in case 21-00222-UT.
That's right. And can you tell us what time frame that covers?
The cover page on this indicates that the statement of the case is in the matter of the application by Zia Natural Gas Company for approval of its 2022 through 2024 energy efficiency program.
Okay, thank you. Can we go to page 19 of this document?
I'm at page 19.
You beat me there. Let's see. Can you read to me the item 6 under the space heater measure?
6, electric to natural gas furnace, comma, AFUE 95% or higher, period.
Okay, thank you. And would you agree that this component of the program would decrease electricity use, but not natural gas?
Mr. Simpson, I am unable to provide any information regarding that based off a singular reference to a one line in a 65-page recommended decision, which I have not reviewed prior to this very instance that you're presenting it to me.
Okay, so you're not willing to accept the title of the measure of electric to natural gas furnace as a reasonable presumption that what we're talking about here is replacing electricity with gas?
There is no context in that singular line that gives me any ability to be able to make a reference or understanding anything beyond the very words that are stated there. And I have no understanding of what those words are referring to, pointing to, or meaning in this context without any additional explanation.
Okay, thank you. Let's go to page 24, and I think this is going to be my last question.
I'm at page 24.
Can you, starting on the second line from the bottom, can you read the two lines there and the two lines on the beginning of the next page?
Beginning with the word finally?
Yes. Out loud, please.
Finally, staff testified that it supports Zia's request to continue its existing commission-approved plan with the small modifications outlined in the application and believes it meets all applicable statutory and rule requirements and is properly designed, reasonable, and fair.
Okay. So would you agree that in this case, it appears that staff accepted the rationale of Zia Natural Gas Company in this case?
No,
I'm
sir.
going to object.
What's the basis for your objection, Mr. Friedman?
Well, these exhibits were emailed to Mr. Dunn today. Everyone else's exhibits have been uploaded to Dropbox. Assuming Mr. Dunn has not had and I believe he testified to this, correct me if I'm wrong, had the opportunity to review these exhibits. I believe it's unfair for him to testify to cases for which he hasn't had the opportunity to review.
I agree with that. Mr. Simpson, so what I will tell you is, although I am going to sustain Mr. Friedman's objection here, you remain free to cite to these recommended decisions in your post-hearing briefing. So nothing prohibits you from arguing at length about the import of these recommended decisions, along with I assume, a proper citation to the final decision and order. But I agree that it's beyond the scope of this direct for Mr. Dunn.
Thank you, Mr. Hearing Examiner. And I have to confess my primary motivation here is to get this into evidence, not to attack or irritate Mr. Dunn, which I'm sure I have irritated plenty.
I'm assuming that Mr. Dunn doesn't take that as a personal attack, but I don't believe it's necessary for a recommended decision or a final decision in order to come into evidence. They're both statements of law. They are legal documents, and you can cite them as such. They're very different from an application or testimony, something of that nature. So I don't believe that that's necessary, but I appreciate that that's your intent.
Okay. With that, I will cease my questioning of Mr. Dunn, and I would like to move or take administrative notice of the recommended decisions and final orders that are my exhibits 3 through 6. It's basically the recommended decision and final order in the two cases 18-00280 and 22-00222.
Well, I mean, I do see that the Commission's rule regarding administrative notice does allow us to take administrative notice of final decisions in other Commission proceedings. Again, I don't believe that that's really necessary, but I will just say for the record that we will consider, we will take a look at these cases that you have cited to, particularly if you cite them in your post-hearing briefing.
Okay. Thank you, Your Honor. I believe that's all I have.
Okay, thank you. All right, so with that, I believe that's all of the cross-examination questions. Hearing Examiner Ryan, do you have anything further for Mr. Dunn?
No, I mean, I would just say for the benefit of Mr. Simpson, I mean, I think one of the interesting things about working in a highly specialized area of law is that the words that appear in statutes and regulations are themselves suffused with a level of specialization that the differentiation between fact and law begins to blur to a point that it may be in fact indistinguishable, that we no longer have two things. We just have one single attempt to get at a concept, and whatever you want to call that fact or law is somewhat irrelevant. So the struggle is a real one, and to the extent to which you're trying to get Mr. Dunn to acknowledge that there are things said in other commission documents which seem to bear upon, phraseology occurring in either statutes or other regs. Well, that's just, the answer is yes. But then the question becomes, how does one then process that? And I think ultimately that's why, as fact finders, the hearing examiners sit as ostensible specialists that are here to parse that, very difficult and kind of like inseparable mush that gets created. So it's for your benefit, Mr. Simpson, for whatever it's worth.
Yeah, thank you. I appreciate it.
Yep.
And so hearing no further questions from hearing examiner Ryan, Mr. Dunn, based on your testimony, I do not have any further questions for you beyond those I've already asked. I appreciate your time and your testimony here. Mr. Friedman, do you have any questions on redirect?
I do not. Thank you.
Okay. Ms. Burns, anything further from EPE?
Nothing further. Thank you.
Okay. And Mr. DeSalen, Ms. Lynch, anything further from CCAE or Prosperity Works?
Nope. Thank you.
Okay. Okay. And Mr. Simpson, again, you're finished with your questioning, sir?
Yes, I am. Thank you.
Okay. Thank you. And with that, Mr. Dunn, you are free to go. We appreciate your testimony here today.
Thank you, Mr. Hearing Examiners. I appreciate you as well.
Okay. So with that, I believe we have concluded the evidentiary portion of the hearing here today. Next up on my list would be to discuss post-hearing briefing beyond what we've already been discussing. So first, I guess let's discuss what issues to brief. Hearing examiner Ryan, I know that I'm going to want briefing on the issues that remain contested as outlined by the statement of issues and I believe it's called undisputed facts, agreed upon facts.
Yeah, just a preliminary question before getting into that subject. And this may be specifically for Ms. Burns, but just, hearing examiner Kreinkamp and myself are sort of late to the party in all of this. We were signed after Mr. Mueller departed from the commission. And I just want to confirm what I understand to be the case, which is that we're operating under no hard deadline. And I don't ask that because I'm suggesting we're going to sit around and do nothing about this case, but more just what time frame do we have to operate under? And my understanding was none, but you can correct me if I'm wrong.
Yeah, I don't think that's accurate. Hearing examiner Ryan, I believe that EPE filed an advice notice in this docket and that there was a commission order suspending it. But I will tell you that I don't have that before me right now. It might take me a minute to get it. No, it would be in a procedural order issued. I mean, typically the energy efficiency cases are suspended for and heard within 180 days. But I will also say that we did not request an expedited transcript in this proceeding.
Right. And I don't know. I mean, if we're stuck on some time frame, I don't know enough about what sort of times we're looking at. And then
well, let me just jump in on a couple of things. One, when the commission originally appointed a hearing examiner, this was on August 12th, the order appointing hearing examiner, in the discussion paragraphs, the commission found that as the plan includes modifications to one of EP's programs, and it therefore contains a program that has not been approved, the 180-day limit on the suspension period is not applicable. That's paragraph 6 in that order. And I believe that when we issued our order granting an extension of time to file stipulation, we referenced that finding. Yes, we did.
Well, then I think that would be the answer.
Well, I mean, that answer works for me. I mean,
Yeah.
I look, I'm only asking so that we can plan. I mean, and part of briefing orders is, of course, understanding what time do we all have, and you all can write a lot and we can all write a lot, but if we're under the gun, then we're under the gun. But if we're not, then we have some freedom. There are some interesting issues embedded in all of this, and if you guys want to take your time to brief them thoroughly, presumably you will require time too. So anyway, back to your point, hearing examiner Cronenkamp, yes, I think that's as a baseline, having those issues that were identified as contested. Tell us if they're still contested and lay out your facts and argument as to why you prevail.
Yeah, and I think in particular, one of the items that I'm going to want briefing on is this question of the avoided emissions benefit. There's this argument that we've heard from staff, from Mr. Dunn, that this is an argument that is most appropriate for rulemaking. One of the questions I guess that I would have is, if the hearing examiners find otherwise, where does that leave us in terms of the record and in terms of the resolution of that particular question? Again, that's not to say that we won't ultimately agree with that, but that's one of the questions that popped up just based on the testimony here today.
Yeah, and I would add to that, just for the benefit of Mr. Friedman, as it's his clients that are arguing that this really should be done in a rulemaking. I mean, you'll find authorities in seminal administrative law treatises talking about if all three, if a sort of administrative action would impact multiple parties who aren't present, due process may sort of weigh in favor of having a rulemaking, because then the parties who aren't present, who will be impacted, will have the capacity to talk about. I mean, I'm cognizant of all of that, and I think I've written stuff about that previously. But I think one of the things to remember as you're reading that materials is, well, how does this commission function? And to the extent to which the public interest, I mean, we want due process for all the parties involved, but I mean, withholding judgment sometimes will impact individuals, as it would in this case, according to the utility and those interveners who would like to see the utility cost test include the avoided emissions. And so I guess what I'm trying to say ultimately is, I think it's a rich discussion, and I've had really, good conversation with hearing examiner Medeiros and hearing examiner Glick about these subjects. So any thoughts you can give us that make that richer, be happy to hear them.
Yeah, and the only other note that I would make, again, just to reiterate the point that I made earlier to you, Mr. Simpson, is that those prior recommended decisions and final decisions in order, again, you certainly are welcome to cite to those in your post-hearing briefing, especially as they bear on these questions, as I think that they at least arguably do. So now with that out of the way, as far as what items we want briefing on, and of course the parties are welcome to brief any other issues that you see fit, but let's talk a little bit about deadlines for briefing. Again, the default deadlines, 20 days after the filing of the transcript for initial briefs, 13 days thereafter for the response briefs. As hearing examiner Ryan has elaborated, there's I think a number of issues that we want to review here, and I'll just ask the parties, I guess, starting with EPE. Are you comfortable with those default deadlines? Do you want slightly more time? Do you want less time? What is your pleasure on this?
So thank you. I appreciate that. EPE's preference is to move as quickly as reasonable to a conclusion. We do have issues with implementing into the next, the 2025 plan year, as we testified about here today. So EP's preference is to, I'm assuming that the transcript will be 2 weeks.
Yes,
So
possibly less.
possibly less, yeah. And so I think that EP would, if, I don't know what the other parties feel, they would prefer to have briefing a little sooner than the 20 days. So.
Okay. Let me then ask some of the other parties, Mr. DeSalen, Ms. Lynch, anything to say on behalf of CCAE or Prosperity Works on this question of deadlines?
I'll go ahead. Thank you, Mr. Hearing Examiner. I think we would like to have at least that amount of time. I mean, one thing that we have that we're facing now is the holidays. Both Ms. Lynch and I are also working on a number of other cases that are pending right now, and a little bit more time might be helpful for us. I'd be willing to go along with the default, but I wouldn't want to cut it down beyond that.
Okay. Anything, Ms. Lynch?
I just also see that even with the defaults, we're pushing up against the holidays. And so parties may prefer, a date sooner. If you're willing and wanting to extend it even farther, we can play around with that idea as well.
Thank you. Mr. Simpson, anything?
Yes, just a personal issue. I'm going to be on vacation out of the country from the 2nd to the 13th, so I would not want to shrink it below the 20-day default. The 20-day default would be okay. Other than that, I'm pretty flexible.
Okay. And staff, Mr. Friedman?
Given the holidays and the workload of staff, I would request that the deadline be pushed further out rather than shorter. So if the tribunal would prefer to stick with at least the minimum 20 days as is required. But with the holidays and such, I would ask that it be pushed a little further out, give staff a little more time to prepare a sufficient brief.
Okay. Well, Hearing Examiner Ryan, we have a situation where several parties, I think, are suggesting maybe it gets shortened. Several parties are suggesting maybe slightly longer period. My own thought, at least right now, I'm open to whatever you think, but my own inclination would be to leave it as is. And then if the parties want to discuss a proposed alternative briefing schedule, they can simply make a filing to that effect, and then we can adopt it at that time. What do you
My
think?
federal courts professor was Thurgood Marshall's law clerk, and as he said, apparently Thurgood Marshall was apparently well known to say, "Rules is rules. Default wins."
Yeah. Yeah.
You wouldn't expect that to come from Thurgood Marshall, but apparently he said it quite often.
All right, so let's do that. Let's we're going to stick with the default time periods right now. Obviously, we don't know exactly when the transcript will be filed. So for now, we're going to stick to the default time period. Again, if the parties are, if you all connect with each other offline and can come up with an unopposed schedule as far as when you want to submit briefs, you're welcome to file that and we'll take a look at it. Otherwise, for now, we'll stick with what's in the rules. So 20 days for after the filing of the transcript for the initial briefs, and another 13 days thereafter for the response briefs. Okay. Anything else from the parties before we adjourn for the day? Okay, I'm not seeing anything. So with that, I want to extend my thanks to everybody who was present today, all the attorneys, all the witnesses, for your participation and professionalism. And with that, the time is 4:25 p.m. This hearing is adjourned and we are off the record.